Welcome to the afternoon session. This is the panel on privacy arms race and do not track. My name is Doug Sicker. I'm a professor here in computer science. I'm also the director of the telecom program. Before that, I spent a few years working with some of you here on the table in Washington, but very, very happy to be back in Colorado. We have a great panel of speakers today. I'm looking forward to hearing what they have to say. But first, I'd like to just take a minute or two to set up the panel. I don't know what was said this morning. I wasn't able to attend, unfortunately. I had other university duties, but I think probably most of this was repetitive, but I'll do it anyway. We have recognized this problem, and I was just joking with the panelists that I'm not sure how much has changed in this privacy space since I stopped doing research on it about 7 years ago. And of course, that's not true. There's been technical developments, there's been standards efforts, there's been other things, but it's one of those things that just seems to move even more slowly maybe than spectrum policy. So it's somewhat surprising. Companies and governments and employers have long sought to acquire and use information about citizens and customers. And there's always been some criticism. Some of it very sharp, some of it not so sharp, some of it a lot of no impact. But we have seen companies step up with policies. We've seen companies try to implement these policies. We've seen companies violate the policies that they have published. We've seen the FTC and others smack them down for these sorts of things. So it's been an active space. A lot has been happening over the years in terms of protecting privacy. And as much as we value protecting that information, we also recognize that it's very good for this information to personalize our web services and other such things. So we don't want to just completely shut it down. But it does bring us to a lot of questions as to how should we move forward, and what should lawmakers be doing, whether that's government agencies or somebody legislatively at the state or federal level. And that's the kind of thing that I want to touch on today. There's a lot of terms being thrown around, things like do not track, the right to be forgotten, multi-stakeholder approach to privacy. And luckily, we have experts on the panel for all of these things. And the nice thing for me is that, as I said, I've left this space years ago, so I'm just going to sit and listen mostly and tell Danny he has to stop talking every once in a while, so we'll take it from there.
What?
So let me introduce the panelists. I'm not going to go into the detail about their bios. Anybody who's up here, they're up here because they're an expert, right? So I'll talk about their present affiliation. Aleecia McDonald is a fellow at Stanford. She's going to be one of the presenters, and she'll present for about maybe 15, 20 minutes, some work that she's looking at. And then Danny Weitzner, who I worked with in government, but now is a research fellow a research scientist at MIT, is going to present some of his thoughts on do not track and process of going forward to make that concept viable. And then we'll have discussants, and we have David Campbell from the EFF. We have Peter Eckersley from, David's from Electric Alchemy. We have Peter from EFF, and we have John Verdi from NTIA Department of Commerce. How I'd like to set this up, again, I'd like to turn it over to Aleecia and have her start with maybe 15, 20 minutes. We'll ask the discussants if they have initial responses, and then we'll have Danny present, and then we'll go into a more open session. Okay? I'm going to try to reserve at least 10 minutes at the end for questions, but I hope that we can open it up earlier than that if people are interested. There's a lot of experts here in the privacy space in the audience, and it could be much more interesting if we have a little more back and forth. So, with that, Aleecia.
Thank you, Doug. So, I am the Director of Privacy at CIS in the Stanford Law School. I've been there about 3.5 weeks, so Doug still has my prior affiliation at Stanford. And I'd like to take you back to about 1995 or so, when the browser wars were going hot and strong. And in the browser wars, I'm not talking so much about the anti-competitive nature, about having Judge Penfield Jackson involved. I'm not talking about whether a Microsoft executive said they would cut off the air supply for Netscape or not. Instead, for the browser wars, I'm looking at having different types of technologies that were put into the different browsers, even down to the point of having competing tags. This was a bad time. We had websites that were branded with "this site best viewed with Internet Explorer," right? And for those of us who remember writing HTML back in the day, we also had lots of if-defs. So you would find out which browser you thought the user was using at the time, and you would customize things for that browser, because it didn't all work the same on all browsers. So that's the part of the browser wars that I want you to keep in mind as I start going through 3 ideas that I'll be talking about that are explored more in the paper that I've written to go with this, and starting with some discussion about how privacy professionals are viewing privacy. And I am not a deep philosophical thinker about privacy. There are some people in the room who are. I am a researcher, but let me give you 2 views that I've found helpful as I'm trying to get a sense of what it is that I think I'm seeing as people are changing the way in the field. People in the field are changing the way that they're approaching privacy. So the first one is what we've talked about in the US for a long time. Users are dissimilar. They have different values. They have different privacy preferences. The same user will have different preferences in different contexts at different times with different trusted technologies or individuals. So it's very difficult to draw a bright line and say, these data collection practices are bad, these data collection practices are good. That's something that's extraordinarily difficult to do. Instead, we should enable users to make choices for themselves, and the way to do that, to avoid the information asymmetries we spent a lot of time hearing about on the last panel, is they need to have notice so that they can make good choices, and this all comes down to user choice. We know we have a problem when users' choices are not being reflected in reality, and they are not able to enact their choices, but as long as they are able to do that, we're fine. So notice and choice, and treating users differently. And then the opposite view to this that I'm hearing more about, I was in Brussels, and a professor there suggested to me that actually privacy and security are the same thing. And I was very surprised by that, because that's not the way that I've viewed privacy and security. I think of them as being very different. But if you look at privacy as being like security, what does that mean? So here we have a model of privacy is something that you keep from attackers. You have users who are under threat. You have good guys and bad guys. And it's you succeeded or failed. You kept something private or you did not. And so this is a very different model from the one that I've started thinking about privacy with. But we've started to hear more people, or at least I have, more people in the privacy field working more toward this notion of privacy is a space with attackers and defenders. And while all users are not the same, they're close enough that you can come to some reasonable ideas of what users would want if only they knew enough to make up their own minds. And so instead of users needing to have all of this information and making choices and being rational actors, instead you have someone who defends the users and writes software to do so, as you would with some sort of malware package or other type of security package. So in the paper, I go into some examples of how this works or doesn't work with these 2 views for local storage objects or flash cookies and do not track. I'll skip those in the interest of time. But those are in the paper more if you're ever bored and insomniac some night. So I wanted to talk a little bit about do not track and how that might touch off another round of browser incompatibilities. I think that's probably a better phrase than browser wars here in particular, sort of. So I think almost everybody here is familiar with this history, so I'll gloss really quickly Microsoft announced that for their new version of Internet Explorer 10, they would have Do Not Track turned on, sending DNT1, by default for all of their users. Microsoft has since changed that to they have DNT1 as part of a bundled installation package. So users see that that is something that they're getting. There are a bunch of bullet points. Here's what happens. And then they can go change that, and they have directions on how to do so at install. So there's more notice. In response to this, one of the board members at Apache wrote a patch to Apache. And what that does is anytime there's a signal that comes in for DNT1 from an IE10 or later user, it simply drops it on the floor and doesn't write it to the log file. And the justification for this is that Apache keeps browsers all on the same page and following the same standards, and that at least the way Microsoft implemented this at first for IE10 was not compliant what we were talking about for Do Not Track at the time. It remains to be seen if anybody will take a position one way or the other for the second round of what Microsoft came to. The DAA stepped forward and said for all of their member companies, so primarily we're talking about the advertising space, they do not expect their member companies to honor DNT1 from IE10. It does not provide enough user choice, was their view. And Yahoo has announced that while they have not yet implemented Do Not Track, when they do, they will be ignoring basically the IE10 DNT1 signal for users. So the bottom line to this is that different parties on the web will respond to incoming signals for DNT differently based on which web browser they believe a user to be using. So this starts to look like that if-def world. Here is a table. This is a subset of the table. The full paper has a little bit more than twice this. So imagine that user Alice is using Internet Explorer 9. She turns on DNT1. She goes to Yahoo. Yahoo, eventually, after they've implemented DNT, will honor that request. Alice upgrades to IE10. She returns to Yahoo. One of the things they're talking about doing is putting up a dialog box informing Alice that she may turn off Do Not Track, or she may use a different browser. But no access to Yahoo until after one of those happens. So that's one possible world. Then she says, okay, fine, I'm leaving Yahoo. I'll go to another site. I'll go read USA Today, and there's a third-party ad network called Acme that's on USA Today. Acme, as a good member of DAA, says, we continue to track you. They provide notice of that in their privacy policy. They even respond by HTTP saying, we got your signal, but we're not going to stop tracking you because you're using IE10. And USA Today is a first party. So under the current ideas around Do Not Track, first parties can continue to do just about anything that they want to with data. What they can't do is then go turn around and sell it. So Alice is protected from her browsing history on USA Today being sold, which is the primary difference if she turns off Do Not Track. All of the tracking could be exactly the same, but she would not have her reading history able to be sold. So this gets more complicated. You could imagine a browser turning around and saying, hey, Acme is stating they're going to continue to track. Our users didn't want that. We're going to be held on the hook by our users. And that's research that I've done in another context. Users will blame the browsers if Do Not Track goes wrong, and they'll blame the government more than they blame the individual companies. So the browser might turn around and say, well, I got this signal from Acme saying we're going to continue to track. We're going to step in the middle and not let that happen. Right? We could tether cookies and make them session cookies. We could make them double-keyed cookies so that they can only be read on USA Today, but not tracked across other sites. So the browsers can then respond. We not only have a matrix, this matrix is simplified to one browser, we not only have a matrix, we have a matrix that then gets arrows and loops and whirls. So I would argue that this could be a mess, and that what's needed is to have very clear policy direction as part of Do Not Track. So last idea, before I turn this over to Danny, is a question of whether ads are the new spam. So spam was a problem for a very long time. It's not as much of a problem. There was legislation attempted with canned spam. There was a lot of pushback on that legislation. There's a whole history there. What's happened is math. And so with math, we go through and we tag things as spam with Bayesian probabilities, or we do crowdsourcing, and we have things built in to filter spam into email clients. And users see a ridiculously small fraction of spam if you're a spammer. You still see too much if you're a user. But the problem of spam overall has been dramatically reduced. So the question is whether ads are going to be treated that way. And if we come back to this notion of privacy as a switch rather than a dial, if you have this adversarial model, and if you note that much of the, by no means all of the tracking online has to do with ads, then we start to hear people saying, well, the solution to privacy is to block all ads. This is a kind of disruptive thought, right? So you can see in the Do Not Track Me interface, they're gamifying this. You can get badges if you block enough trackers. It will congratulate you on how many you've blocked. So there's a very different user feedback. Tracking is just bad in this world. Ad blockers are extremely popular for web browsers. They're perhaps the killer app for Firefox still. And I'll call your attention to a piece of research that surprised me. This was at WPES a couple of months ago. Some researchers from Indiana took the view that for privacy, they would block ads, and they also added analytics. And so they were looking for how do we programmatically identify what content is or is not an ad, and then how do we block it. This is not too dissimilar to what Microsoft built into IE initially in response to the FTC calls for greater consumer control. And they did tracking protection lists, so again, content would not load. So we may have this adversarial model come in. It changes the solution space. It changes the ability for people to negotiate together. And as we're talking about multi-stakeholder processes, it makes it very difficult to find something that is a win for all of the different stakeholders if we get locked and embroiled into this win-lose type of situation. Thanks.
Thank you. Danny?
Thanks. Hi, everyone. So thank you for having me. Thanks to Phil and to Paul, and thanks to Doug. So I want to just try to, it struck me in this conversation that we kind of veer around from these kind of very broad privacy principles to very, very specific, what are the details of an HTTP header that talks about tracking or not. So I want to try to just say a little bit about why I think we're here, other than to update Doug on the last 7 years of privacy policy. But hopefully we'll do that as we go on. So I think, first of all, we're talking about Do Not Track because there is a real level of public concern about the kind of tracking that's going on. There does not appear to be enough concern that people are abandoning the web or installing all these kinds of ad blockers in any significant numbers. But we know from just one browser, Firefox, that was one of the first to implement the Do Not Track feature, 14% of Firefox's users today have set the Do Not Track flag on their browser. So there's obviously, now that comes at neither any cost nor any benefit to them. So I'm not sure we can take that as a real survey result, but it is at least a kind of a snap poll of how people feel about tracking. At least that percentage of the Firefox using public doesn't want it. I think the second reason we're here is because, as Commissioner Bill pointed out, and as Julie Angwood pointed out, the internet advertising industry, in the form of a trade association that has hundreds of members and leading companies such as Google and Yahoo, came to the White House just about a year ago, February 23rd to be exact, came to the White House and made a number of commitments. One commitment was that they would adopt a set of enforceable code of conduct about how to do behavioral advertising, and also that they would implement a Do Not Track feature that would make it easier to trigger the opt-out in that larger code of conduct. So they're on the hook for a commitment. And I think it's fair to say that there's a fair amount of head scratching going on amongst the companies, amongst advocates, amongst people at W3C. I can't speak for the regulators or policymakers, but I think they're probably paying attention about whether this commitment is going to be fulfilled or not, and if so, how. But I think there's something actually much more practical at stake than all those politics. I think what's at stake is whether users, whether internet users around the US and really all around the world are going to have the benefit of an easier to use feature that controls how their personal information is collected or used. That's really what this is all about. Do you have an easy way to do it, or is it going to be a lot harder and a lot less reliable? I differ here, I suppose, just a little bit with Aleecia. I think the reference to the browser wars is really apt. But I think we have a different kind of dynamic going on. It is the case that if everyone decided to use Do Not Track today, that is, if all the advertising networks, all the profilers who are out there collecting information about users wanted to use Do Not Track, they would have a big conundrum about how to do it in a completely interoperable way. And then we would have this kind of browser war problem. But in reality, what we have is we have the key implementers, the ones on whom users are dependent, that is these ad networks who are doing the profiling, who today are paying no attention whatsoever to the Do Not Track signal that they get from the 14% of Firefox users and others. So we don't so much have a browser war as a kind of a browser indifference as to this signal. I actually happen to think that browser wars were kind of good. They were a little bit unpleasant, but at the end of the day, what helped them to resolve through the World Wide Web Consortium, as Aleecia mentioned, was a real set of interoperability standards that made the web into something that could work globally. That only came about, as with many standards, but particularly internet standards, that only came about when all the parties realized they had a mutual interest in interoperability. Right now, the parties have a mutual interest in, well, the parties have no mutual interest. Some of the parties have an interest in not paying attention, and others have an interest in being paid attention to. So the task is, in some sense, how to bridge that gap. To try to answer the question about how this process is going and where we might go from here, how we might actually get to the point that users actually have the benefit of these kinds of capabilities. I want to try to locate the Do Not Track debate in the context of how we approach commercial data privacy policy in the US. And I want to suggest there are basically two categories of the way we handle data privacy issues on the commercial side. I'm keeping the government out of it for now. There are certainly those cases where the harm or the objectionable behavior is clear enough to the general public, to policymakers, that we make laws. We say, as Commissioner Brill alluded to, we say there are real limits on what you can collect, what kind of information you can collect and use about kids. We say there are real limits on what you can do with health information, with finance information, with genetic profiling information. We have a whole bunch of laws that sidestep all the debate that we've been having all morning about just what the rules should be. We just decide, and we don't rely on any complex industry dynamics and pressure from regulators or anything else. We just say, here's the rule, and people have to follow it. But as you heard from the discussion this morning, when our collective assessment of harm or of privacy intrusion is somehow more subjective, what we do is we fall back to a framework in which we say, we want to give individual users choices and some control and some notice and some other things, but really we want to give them choice about whether they're going to enter into certain relationships with their personal information or not. And we really want to let users make the decision that we regard as fundamentally subjective. How do you feel about profiling? If you feel okay about it, you just go along your merry way and you're profiled quite aggressively on the web. But if you don't like it, we want to provide you a way to make some choices. Now, when we're in this second category, where we haven't made a law The FTC, as you heard, does have some very broad legal authority to enforce against unfair and deceptive practices, but the FTC has no authority whatsoever to instruct either browser vendors or advertising networks to provide this user choice. What the FTC has, what the White House has, what other parts of the US government has, is what Peter Swire has referred to as a kind of a bully pulpit authority. We can try to cajole and persuade industry into taking steps that we think are responsible. And in many ways, as both Peter and Deirdre Mulligan have documented, and I won't go through it here, in many ways the last 15 years or so of commercial privacy policy in the US has been based on this kind of model of cajoling and persuading and convening, trying to get companies to do the right thing, to adopt reasonable practices and practices that can be enforceable. And that's where the whole do not track debate is. I don't think anyone thinks there's a serious possibility that Congress would actually pass a law mandating do not track. So we're in this somewhat squishier arena of persuading and cajoling. That arena, I want to suggest, has two sub categories to it. There's the traditional bully pulpit approach that the FTC has taken for quite some time, in which the FTC on its own, in loco cibus, more or less, in the place of citizens, goes and pushes companies to adopt certain practices. That's the way most of the practices that the online advertising industry has been following for the last 15 years have been adopted. They've been private, closed-door, non-transparent, non-multi-stakeholder negotiations, which have resulted in a whole set of principles, and occasionally, and those principles get enforced by industry self-regulatory bodies, and occasionally the FTC steps in and says and finds situations in which there are certain industry players who don't abide by those principles, and then we get enforced. Then it gets enforced against them. Here's what's, I think, challenging about the do not track process. And then I should say, we have John Verdi at the end of the panel representing the new face of this kind of privacy negotiation, the open multi-stakeholder policy negotiation process in which we hope to get all the different stakeholders get together to agree by consensus on privacy practices in particular contexts. That's the second kind of bully pulpit activity. Again, they're both voluntary. And I think what's challenging about the way the do not track process has gone is that it's had a little bit of both. The discussion about what practices ought to govern behavioral advertising was a discussion that was initiated in a traditional bully pulpit fashion by the FTC, actually by now Chairman Leibowitz when he was commissioner in 2007 or 6 or so. And the result was a long interaction between the FTC and the advertising industry, and they came to a set of principles that they agreed to live by. They agreed that it would bind hundreds of the online advertising networks that do the kind of profiling that we're talking about. They set up a self-regulatory body with the Better Business Bureau that actually goes out and investigates the various online ad networks to see whether those practices are being followed or not. And we can talk more about the details of that. But that process started in a kind of a traditional bilateral fashion. Somewhere along the way, a number of different voices in the community, including the FTC, decided it would be a good idea to add to that negotiation the do not track feature, and brought in the World Wide Web Consortium, as you heard about, an organization that I used to work for and have a huge amount of respect for, to try to help work out what this do not track feature would actually mean. And what I want to suggest to you is that as we look at the first cycle of W3C's work on this effort, Aleecia has just finished very distinguished service as the co-chair of that group, and Peter Swire is coming in to do the second phase, hopefully the last phase, the successful final phase. I think we learn a couple things about the strengths and weaknesses of using what are really technical standard setting processes that work on a purely voluntary basis for addressing these kinds of challenges. W3C is the kind of unquestioned authority on technical standards for the web. It's W3C that solved the browser war problem because everyone agreed to get together there, and because W3C had technical leadership and trust from the community to resolve all those questions so that we could have one interoperable web. One of the very important aspects of the way that W3C has worked and has been successful is through what I would characterize as an iterative design and deployment process followed by standardization. So people get together in W3C working groups, they talk about how you might approach a certain problem, and then they go out and implement it. And the groups actually look at how those implementations are working out on the web, see who's using what, see whether they function well, see whether they're widely adopted, and then we'll eventually put those into final standards. But that's an iterative process. I think that one of the challenges that the do not track process has had at W3C is it's had essentially none of that iteration. It's been sitting in a very, I think, good faith fashion with lots of effort to try to resolve a whole series of public policy questions, a whole series of questions about the definition of do not track. These were questions, I have to say, that I think had always been present, and I think the Washington policy community had hoped somehow that these questions could be brought into this technical forum and somehow by magic resolved. I think that what we've learned is that there's a set of technical questions, a set of public policy questions rather, that are not necessarily susceptible to consensus answers. They are not questions that you answer by asking what works best, what technology design will achieve everyone's interoperability goals. They're questions that are about policy values, about what we think is a fair way to treat people, about what we think reasonable business practices are, about whether we think a certain design will unduly impair the business models of advertisers, about whether we think that same set of business models is somehow unreasonable to impose on users. And I think it's, to be blunt, I don't think W3C is good at resolving those kinds of questions. It just doesn't have the capability. It's not what it was set up for. It's never really done it before. So going forward, as I noted, W3C is at an important inflection point in recognizing that it has a series of hard problems. The public policy community, I think, is looking at the do not track debate and saying, well, this commitment that was made a year ago is come due, at least in February it will. The question is there a way to move forward? Is there a way to get any of this technology actually out there and usable in the hands of individual internet users? My own belief is that the public policy process put an unreasonable and unsustainable burden on the technical standards process. And the public policy process is going to have to help the technical standards process with direction on decisions. What I want to be very clear about what this means. Do not track is a deceptively simple sounding idea. It fits on a bumper sticker, which is great. But when you get into the details, several panels referred to it and said the devil is in the details. We could talk a lot about the details here, maybe we will. But suffice it to say that I don't think anyone really believes that do not track means no tracking ever whatsoever for any purpose. And I think everyone also recognizes that individual users, as Aleecia suggested, to a large extent have the unilateral capability to block all tracking if they want to. The problem is they lose a lot of functionality, as Doug suggested, of the web if they do. So the definition of do not track is at some point to be defined in between no tracking at all and complete tracking. I think we know it's not either one of those. And I think part of what could happen going forward is for the industry to get together and agree on some minimum set of requirements about what do not track means to them. Privacy advocates might not be 100% happy about that. Regulators might not be 100% happy about that. But what we would have is we would at least be on the road to a working system, a system where when users click a button, they get a result. We can then argue about the result. And there may be a variety of forums in which to argue about a result. But we would be arguing about how an actual system is working and how actual users are responding to it, as opposed to having an abstract debate which so far has not resulted in any material change for the way that the users experience the web. And I think that it is really, for better or for worse, up to the public policy community to establish what that minimum starting point is. Because remember, today, one of the great strengths of the World Wide Web Consortium process has been that it's voluntary, that it is the basis of people coming together who want to have their systems work together, who want all browsers to display all web pages more or less the same way, who want all these tags to behave the same way. For us to get to that point, we have to have some baseline agreement about what the basic functionality of a system is, and then I think lots of developments could happen from there. So I think that it's a really important time in my view because we're closer, I think, than we ever have been in the privacy world to the possibility of really, really easy to use user control for individuals. We've always argued in privacy debates about the burden of opt-in versus opt-out and had a kind of a cynical debate about whether people are going to expend the effort or not to take control of their privacy. If we can find the right middle point on do not track, I think we can really get past that dialogue to the benefit both of users and of the industry that will have a better sense, a better trusted relationship with its users. But I think someone with authority is going to have to define what the first step is. So thanks very much. Look forward to the discussion.
So before we get into the discussion with the discussants, I'd like to temporarily elevate my former colleague, John Verdi's, to a presenter and ask if you can just give a few minutes discussion of what's going on in the Department of Commerce multi-stakeholder effort.
Sure, I appreciate it. I also appreciate Danny calling me the new face of anything, which I will take at my age. I'm pleased to be the new face of anything, Danny. But yeah, in terms of what's going on with our multi-stakeholder process at Commerce, we convened the first process in July. It's focused on developing a voluntary code of conduct for mobile app transparency. The theory is that we have convened business folks, academics, technical experts, consumer advocates in a multi-stakeholder process that is going to develop a code of conduct that companies in the mobile space can voluntarily adopt, at which point it would become enforceable under the FTC Section 5 deceptive trade practice jurisdiction. And we have asked them to work together to come up with a code that provides greater privacy protections for consumers and also greater certainty for folks in the mobile space. some of whom are very large companies who all of us know and visit their sites and use their mobile apps every day, but many of whom are small app developers who don't have sophisticated legal counsel or a lot of policy expertise. So the idea is that this code of conduct would be simple enough for companies to implement in an effective way, that wouldn't be terribly complicated, and that it would achieve benefits for both consumers and businesses. Now, how is that process going? It's going very well. The stakeholders are moving forward constructively. They're actually working on a draft code. The next meeting is January 17th. I will be back in Washington, D.C. Sad to leave everybody here in Boulder. It's a lovely city. And I'll be back in Washington facilitating that meeting. And we'll be talking about very granular, very specific wordsmithing changes that stakeholders have been meeting about and discussing between the last meeting in December and the upcoming meeting on January 17th. Now, that isn't to say that we have anywhere near a final product in that process. There are still genuine disagreements among stakeholders about how to convey notice and transparency about privacy practices on really small displays. And the stakeholders are working their way through that. So it's been a constructive process. It's been a process that is moving forward to what we hope will be a very successful conclusion. And we anticipate that NTIA, part of the Department of Commerce, will be convening additional processes, multi-stakeholder processes, that will address other business sectors that aren't mobile in the future. And we look forward to working with stakeholders into 2013 and beyond.
Thank you, John. Let's turn it to Discussants. David, would you like to begin?
Sure. So first off, I have to say that I agree with Danny that for DNT, the best next step is probably to look to industry to get together and start to agree on what it means and what appropriate responses to those signals are. I think that's just a fantastic idea. But what strikes me, and this really only just came up now as I was sitting here when Aleecia was talking about the browser wars. I remember them very well. And for me, the most poignant aspect of the browser wars wasn't the fact that my web page wouldn't load perfectly in IE and in Mozilla or Netscape or whatever. It was the crypto wars that came about at the same time. So for those of you who don't remember the crypto wars, this was basically the assertion that the cryptography required to allow e-commerce to exist on the nascent internet was considered a munition and was prohibited from export by the US government. The compromise was initially that only very weak encryption could be exported, and the net result was that it was impossible for people outside of the US to use decent encryption on the internet. And so looking at this problem of do not track through the lens of not just the browser wars, but the crypto wars, I think we really need to look at the lessons that taught us. And do not track is a mechanism that relies on the honor system. So I say, do not track me, please. And I hope that the good actors on the internet will say, okay. And what we've seen so far is that even the good actors can't agree on what it means when I say, please don't track me. So to look at that from the perspective of the crypto wars, what if we said when we went to Amazon.com to buy a book, instead of using real good cryptography that made it such that only Amazon could get our credit card, we said, well, bad guys, please don't take my credit card. I feel like DNT is functionally equivalent to that at a technological level. Looking at it from the perspective of, are we looking at a privacy war that's functionally equivalent to the browser wars and the crypto wars? I've never thought of it from that perspective, but it seems that we could be headed in that direction. So if the policy folks can agree on this, so the industry people get together and say, here's what DNT means to us, the regulators can work with the legislators and we come up with a happy framework, is that going to be good enough? I don't know, but I do know that what we're doing today is not good enough. A common argument I hear when I talk about having privacy by design and anonymity by design is that it'll break the free content ecosystem that exists today, where everyone uses Facebook for free and everyone uses Gmail for free. And if we make do not track have teeth using technological means so that you really can't be tracked when you say I don't want to be tracked, will that break the internet because all this free content will go away? And I don't think that's the case. If we allow industry to start compensating people for sharing their personal information with their consent and with their knowledge, they will be able to use these services. So it won't break the internet going down that path. But in summary, DNT, fantastic idea. It's been slow to reach the finish line or really even the starting line. But I would be open to encouraging more technical discussion about other means in addition to please don't track as a way of going forward.
Any rebuttals or discussion on that?
Peter, you haven't come in yet?
I have some things I was going to say, but so we're on a panel and we're talking about, nominally talking about arms races, but actually we've mostly been talking about do not track. And I thought perhaps it would be good to tell a story about the connection between arms races and do not track. How did the world get from one to the other? And I'm going to start with Aleecia's point, which is that computer scientists I'm a computer scientist, computer scientists who study privacy often think of it as being closely related, maybe even the same thing as computer security. And we've learned quite a lot about computer security in the last 20 or 30 years. And one of the biggest things that we've learned is that it's really hard. Why is it really hard? Not only is it really hard, it's actually really hard in a counterintuitive way. It's hard in the sense that as our devices get more sophisticated and more advanced and more high-tech, they get less secure rather than more secure as a general rule. That's the natural direction of gravity, if you like. And why is that the case? Well, it's because we're carrying around these objects in our pockets that have millions or billions of moving parts in them. I mean, we can't see them moving, but inside there are bits, ones and zeros flying around. And also attached to this incredibly complicated system is a camera, 2 cameras actually, 3 or 4 radio devices, a microphone, enormous amounts of stuff going in there. And from a computer security point of view, the question is there some input that goes somewhere into this enormously complicated machine that makes it do something that you hadn't expected? And the answer is, not only is there one, but there are literally tens of thousands of things you could send to my computer or my phone that would trigger a bug somewhere obscurely inside this very complicated system and cause it to send you my credit card details or tell you about my love life or spy on my keystroke, whatever it is. So that's the problem we face with computer security. And if you're trying to defend the computer, you have this situation where I know there are 10,000 bugs in here somewhere. I have to find all of them and fix all of them. Whereas the person who wants to break into the device need only find one. And this fundamental asymmetry has given us a belief that to first order, in simple cases, in computer security, the attacker tends to win. And now what we have with privacy is a very analogous situation. I'm just going to take the example that we've all been talking about. It's only one example of a kind of privacy threat model. I'm a person using a browser, and I don't want my reading habits obtained by any parties that I have no relationship with without my consent. That's the online tracking problem. There are all these companies that know what you do, and you've never heard of them, have no relationship with them, certainly did not agree to allow them to record your habits, and yet they do. And the problem is they have lots and lots of ways that they could obtain that data. They started off perhaps using cookies and referrer headers. These were simple, early, like 90s web technologies. And so people went along and said, oh, we're being tracked with our cookies. Here, let's write software that deletes the cookies occasionally or blocks them or messes with the referrers or whatever. What we saw after people started to be aware of cookie privacy is that a bunch of these online tracking companies went and started using technologies that we called super cookies. They functioned like cookies, but when you deleted your cookies, the flash cookies, the LSOs, were still there because Adobe had written another mechanism for tracking you. They maybe hadn't intended it, or maybe they had, but it was there, and so a whole lot of companies were using it. And then people might run around and try and block all the super cookies. There were like half a dozen kinds of them, the Adobe one and 5 more. And then what we found is companies are using fingerprinting which is this even more subtle and sneaky technology where we actually did an experiment on this. There's a website you can go to if you have a browser in front of you, panopticlick.eff.org, where we ran an experiment on how much you could track a browser, just not with a serial number like a cookie, but looking at the settings and version information and the size of your screen and a whole lot of innocent, apparently non-unique or identifying things that a site could just see about your browser. You put those all together, it turns out your browser's unique. Everyone's browser's unique. We're all like little snowflakes. And it also turns out there are a whole bunch of companies out there selling fingerprinting technologies to online tracking companies so they can use it to track people who block cookies and who block super cookies. So that's an arms race. It's an arms race between people oh, I'm going to block my cookies? Oh, wait, haha, we tracked you anyway. And if this arms race happens naively, if we just sort of bumble along trying to do better for privacy, the trackers are going to win. And so it was confronted with this arms race that we at EFF, for our part, decided to try and help make Do Not Track happen. We said, look, if there's this free-for-all where companies feel entitled to go and fingerprint you or super cookie you or who knows what the next thing will be as soon as they see you blocking the last thing that you did, then it's going to be a long and painful road to privacy. Instead, let's go to the browsers, let's go to Mozilla, let's go to Microsoft, let's ask them to add a simple setting that says, by the way, I blocked your cookie, but also, or maybe I didn't, but also, actually, it's not okay. You do not have my consent to collect my reading habits. Unless you've actually gotten it from me, maybe Google got it from me explicitly in a negotiation, maybe Facebook did, but a random company I've never heard of, no, you don't get it unless you can persuade me what value you're giving me in exchange, unless there's actually a marketplace negotiation that's present. And so that's why we, for our part, encouraged this idea. And what we saw from industry in response was an unwillingness to accept that proposal. And I think that was probably a mistake on industry's part. I think that, as Aleecia said, there's other stuff that people who get mad about privacy are going to wind up doing. In particular, they're going to wind up blocking the ads. Now, a thing about ad blocking, maybe not all of the ads, maybe just the ads that don't respect Do Not Track. It's going to be some kind of complicated measurement of like, well, this is an ad, it keeps cooking me even after I do not track it. All right, that one gets blocked. And the thing about that kind of dynamic is it switches the asymmetry of computer security around. When you're trying to defend your privacy, there's always going to be a way to track you. And you're not going to even know that it happened. It's going to be 2 years later, some researcher publishes a study showing that you were being tracked with super cookies for the last 2 years. You didn't know it when it happened. But when it gets to visible ads, the symmetry goes the other way around. If you've got a company that you know isn't willing to play ball with a reasonable Do Not Track standard, people are going to block their ads. And if the ad gets through, you notice, it's like, oh, another ad got through. And so the people over at AdBlock Plus have been doing this. They've been playing that arms race, not for privacy reasons. Their story was, we do this because ads are annoying. But I think what you're going to see is the only option people are going to have for privacy will be something like AdBlock Plus. Go and install a version of AdBlock Plus that targets tracking ads. And that's the world. I don't think it's a great world for us to live in. I think there's going to be all sorts of fights and incompatibilities and the problems Aleecia's been warning us about. But because industry has insisted on do not track means pretend not to track, I feel like that's where we are in this arms race.
Thank you, Peter. I think both Danny and Aleecia have something to respond to.
So I love the fact that we're talking about the crypto wars and the privacy wars. It's great, and I think we're at a law school and we're talking about technology, and I think it actually gets to a really fundamental issue about the relationship between law and technology and the kind of tools that the legal system and the technology infrastructure has to address what I consider to be fundamentally a social question, a question about people, not a question about the behavior of machines. And Peter, it's really interesting to me that I think that privacy is not is hard in a different way than security. Because security, one has to adapt to the behavior of the most threatening adversaries. I think it is the case that in privacy and consumer protection law, in most law, that we generally believe in our legal system that we can make rules and people will follow them. So exactly to your point about cookies, super cookies, local storage objects, whatever comes next, that I think we believe in our legal system that if, for example, a company says they're not going to collect certain kind of information about you, then they can't do it, then they won't do it, whether they do it through cookies or super cookies or this or that or the other thing or something we didn't think about. And if they do, it's either because we wrote stupid policies that were too technologically specific, or the regulators were, asleep at the switch and should have gone after them. And I think what's striking to me is that I guess I'm less sanguine than you are that there will be a mass revolt causing a kind of collapse of the advertising, of the online advertising economy. That was predicted 10 years ago when there was kind of the first round of online advertising debate, and there were some people who blocked some ads, but it was a pretty small number, and I think that I think the arms race there will go both ways, and my guess is, I think I worry a little bit more about making sure that we have the legal tools to protect consumers than about hoping that consumers will become technologically sophisticated enough to stay ahead in the arms race. And I think that's kind of the same conclusion that you came to in working on Do Not Track. But so I think that being clear that our goal here is not to engineer a perfect technology, but it's actually to have a technology that can signal a social and legal agreement that everyone has agreed to live with, and that the ultimate enforcement is some combination of law and public pressure, not so much, the next more powerful technical weapon.
Can I respond to that real quickly? So the idea of using the legal framework to enforce good behavior on the internet is cute, but our legal system is national.
Is that what you're saying?
It's national, but the internet is global. So try explaining to the Eastern European crime syndicates that.
But we're not talking about crime. We're talking about the behavior of businesses that are visible in the United States, that are subject to U.S. law, that have money, that at the end of the day we can track down. I agree that the computer crime problem is not a problem that gets solved this way. But I don't think this is a crime problem. It may become a crime if someone violates the rules, but I think the vast majority of the profiling that we're worried about here is actually conducted by businesses that consider themselves to be legitimate. They may not be if they keep breaking the rules, but we have to decide what the rules are.
Interestingly enough, Canada disagrees.
How's
Canadian law, so there's a reason why the Canadians didn't get involved with Do Not Track from the beginning. They said, all of this tracking violates our laws. We don't want to give notice and choice around it. We want it to stop, right? So your point being that the internet is a very worldwide place, I think is true, and it's by which laws is it legal or not. To come to a point that Danny knows very well, but he gave shorthand for just to make sure everybody else gets this, it wasn't that the FTC imposed upon W3C to do not track. Rather, there was a member submission from one of the members within W3C that proposed W3C take on do not track. That happened to be Microsoft. It could have been any of the members. So that's how that process kicked off. It was not at the behest of regulators. And I know you know that.
It was embraced by the regulators.
I know you know that,
yes,
but just to make sure everybody else knows that too. So to respond a little bit to David's point before of, well, maybe what we need to do is have industry go off and figure it out on their own, and then we can add more people in. That's actually what got us to the point today, right? They've failed at that. So if you look at the ICON project, There are some really good things that came out of that in terms of transparency and notice and choice and control, and that's really interesting work, and they've done a ton of work. And I'll tell you, I appreciate that more, having done the W3C co-chair role for 1.5 years. Like, that was hard what they did. So huge props there. But here's what they didn't do. What does it mean to opt out of behavioral advertising? Well, there are 3 different things it can mean. And it's been implemented in 3 different ways. And it could possibly mean more, right? But it means at least these 3. In some cases, companies doing behavioral advertising say, oh, well, if you've opted out of behavioral advertising, there is no economic value to me anymore. I am deleting cookies. I am not tracking you anymore. Every time I see you, it's like the first time I've seen you, and I see your opt-out, and I'm done, I'm gone, right? It really means no more data collection. Second piece, one of the approaches Google took was to aggregate all data at the point of collection. They set a cookie, and instead of the unique identifier 1234, instead of that unique identifier, it says opt-out. And so all of us having an opt-out cookie would be like a giant user, and then you can't distinguish even how many people are involved and what they've done, and so it aggregates at the point of collection, which is actually a fine way. All of Google's code still works the same way. They didn't have to re-architect their systems, and they continued on their merry way. Third choice was what Yahoo did, and Yahoo said, okay, you're opting out of seeing targeted ads. We collect all of the same data, we use all of the data the same way, but you no longer have transparency to it, because the one thing that we don't use it for anymore is showing you targeted ads. So if we look at what went wrong with the existing program, that's huge progress, right? It's not just that if you clear your cookies, you also clear your opt-out cookies. It's not just that you might have to go to, as we talked about before, hundreds of companies. Those are things that could be solved in the browser without needing do not track in a far less contentious way, right? And Google started to go down that path for some of their building in ways to not clear cookies, and you could do that intelligently. The question is, what does it mean to opt out? Just as it is, what does it mean to stop tracking? Industry tried. They weren't able to come up with it either. And so we're building on that work and doing a second round. And so that's where W3C came into the process, is that industry already tried that and got stuck.
So, John, back in the discussant role.
Thank you. I accept the demotion gladly. So I have a question for Aleecia about her metaphor, your switch and dimmer metaphor. Right? Mm-hmm. And my question is, from a user's perspective, not from the company's perspective, but from a user's perspective, is what is going on here a dimmer versus a switch within those 2 paradigms? Or is what is going on here something else? And that something else I would describe, keeping it within your metaphor, as not a single light, but say a chandelier with 100 lights or 1,000 lights or 10,000 lights, right? And what the user has right now is a series of 100 or 1,000 or 10,000 dimmers and switches in front of them, which they can adjust to effectuate their privacy preferences. And what they would really like is your single dimmer, right? And my question is, for users, you know, people have said dimmer, people have said volume knob, things like that. You know, is that a more beneficial metaphor to think about this privacy versus security, or privacy as security concept?
So to go back to studies that I've done for users, and so my data is now a couple of years old, and things may have changed for perceptions in the meantime. And some of it's only about 1 year old. But when you talk to users, what they want is to be kept safe online. They think government already does that. They think there are laws in place that do that. So that's part of why there hasn't been this mass exodus, perhaps. They mistakenly believe they're already protected. But when, for example, we talk to people about what they want do not track to mean, right? What they really want is a magic keep me safe online button. One button they push, they don't know what it means. They don't know what that would do, right? They don't even know what they're necessarily concerned about. And so if we're going to take this as the one switch that flips on and off, the risk here to companies is that for all that they're very frustrated right now, I think, and I think Danny captures some of that, right, of some of the frustration of industry went through this really painful process to do icons, and now they're being asked to do not track, and when does it end? And right, I mean, I've heard that from many people in industry. The problem is if we move to this sort of we're going to just treat ads like spam model, industry can't negotiate with a filter. They have no negotiating partner. It's just done. Right? So I think users claim that they want a magic keep me safe online button. If they had that, they might suddenly say, oh wait, I want more points of light. Right? It might be too coarse for them. Part of the thing with do not track is to then also be able to go back to users and have a company say, okay, but you trust us, and be able to get that one-on-one consent. That's great if you're a first party with a prominent brand. And a first party actually isn't going to need to have that, right? If you're a first party also with a third party component, and you have a prominent brand, that's not so bad. If you're a third party nobody's ever heard of before, you're having a tough time getting consent. You have to explain very, very well, and then you get that value proposition that Peter talked about. Here's what's in it for you. Right. So I think users believe they want one switch. And do they actually? Probably not quite, but probably closer to that than the chandelier.
So Peter or David, do you have any more comments
think
you'd like
that-
to make? And then
Sure.
we'll turn to the audience.
Sure. So I agree that users want that magic button, keep me safe online. I've been working in security forever, and that's what they want, and we can't give that to them for the reasons that Peter so eloquently described. It's literally very difficult to do security well, but part of the reason it's so hard to do security well is that we're doing it on an internet that was developed for open communication between universities in the 1970s. So we're trying to lay on this layer 7 header that's going to fix these kind of problems, or at least attenuate them, and it's not, I think, a winnable battle. We need to look lower in the stack. We need to reevaluate our assumptions and do some pretty fundamental re-architecting and re-engineering so that we can get to a point that we can provide the user with that magic button.
We're dealing with an internet that was designed to have commerce banned.
Mm-hmm.
It's a different world.
I wanted to bounce off something Danny said, which is about the relationship between technological solutions to privacy problems and legal and regulatory solutions. And you pointed out, well, you know, we have these mechanisms for establishing consent and agreement in the legal system that, you know, contracts, terms of service, etc., privacy policies.
And laws sometimes.
And laws, absolutely. The problem we have trying to get online privacy through these mechanisms is that they're unilateral contracts of adhesion. We have one group of parties who have a lot of power who write those, and then consumers who don't and can't read them. And probably if we wanted to go down this road and figure out how to use those well-worn and often successful legal tools to make progress on this privacy problem, I think the first place we'd want to look would be, how do you stop them from being such unilateral objects?
And I think that the role that the FTC has taken in this bully pulpit position on advertising, and this goes way back, you know, this goes back to the 1950s. This is pre-internet. I mean, the FTC has always had a policy concern about making sure, about balancing out the imbalances between consumers in the marketplace and companies that just inherently have no leverage. So I agree. I mean, that's been something that the FTC, I think, very often has made huge contributions on, and has done it in a pretty nimble kind of way. I think, you know, part of the reason that when I was at the White House, we issued a statement on the Consumer Privacy Bill of Rights and said that we need a consumer privacy protection law, because we don't really think that, we did not think at the time that this method is going to be scalable to the entire information economy. We do need some more clear rules. But I think getting those right is not simple. But I think that unless we're going to kind of retreat back into really what is a crypto mentality of kind of telling every person to protect him or herself using the best, you know, munitions they can find, I don't think we really want our economy or our society to have to be that way. I don't think we want citizens to have to function that way. So I think that this effort, though it's at a complicated point, has been really important in establishing what the contours of those social rules might be. And Peter will get it over the finish line.
So I didn't leave quite enough time for as many questions from the audience, but there is time for one or two maybe. Does
Doug, you know to call on the student first.
yes. Oh, I didn't know we had that rule because the students aren't here yet, are they?
Yeah, they are.
They are?
My students are here.
Mine are. There's no engineering students here, so I'm disappointed. Okay. I'm sorry? Paul, you call on a student if they don't.
Daryl's raising his hand.
What? Oh, yeah.
Yes, I just had a quick question. With pop-up blockers, like there was once a point at a time where there would constantly be, and you would constantly having pop-ups pop up all the time. And eventually we got to the point where every browser assumed that we didn't want pop-ups on our screen. And if there were, for some reason, a reason why it was necessary, they would ask you, do you want to disable your pop-up blocker for this site? And I feel like if you have a small town newspaper, you can say, oh, would you like us to allow advertising or allow our partners to track? Like, I feel like wouldn't that be a solution that solves the same problems?
So, to take the first part in terms of pop-up blockers, and I'm sure other people will want to weigh in, especially on the second part. What's interesting when I do user studies, if I ask people just a very neutral question at the beginning, what do you think of when you hear the phrase internet advertising? The two things they think of immediately are spam and pop-ups. Still. Once burned, people take a very, very long time to get over it. And so if advertisers are seen by users in this adversarial mode of being bad guys, I think it will be a very long time before people get over that. In terms of why don't we just always ask users to track them, wouldn't that be easier than having users have to say they don't want to be tracked when that turns out to be what the majority of the population wants by studies that Microsoft has done and others? That was Microsoft's justification for the way that they handle DNT in IE. What's the problem with that? The problem with that is money. Companies look at that and panic as they think about how much revenue they would lose for a system that is inherently voluntary. So do not track would not survive the financial hit to companies if we tell them, please voluntarily adopt the system that will put you out of business. Just flat out, that's where it is. Whether it's good or bad, but that's where it is. Anybody else?
I think Barron had his hand up in the back.
Thanks, Baron Soka, Tech Freedom. The word voluntary has been used a lot on this panel. Calls to mind my favorite line from The Princess Bride. You keep using that word. I do not think that word means what you think it means.
I think I was actually the first one to use it on this panel, but okay.
It was used a lot.
I used it too.
Did
I
you?
used it.
I like it.
I guess I really don't know what it means.
Well, this is important because the conversation you've been having presumes that the sorts of encouragement, the bully pulpit, all that stuff is voluntary. And let's set aside just for a moment whether we think it's good or bad. It might be the best thing in the world. But really? Really voluntary? I really find that hard to believe. Now, there are threats and then there are threats. Tim Wu, who of course is the father of net neutrality, taught me internet law, great guy. Tim Wu has come out and said that agency threats are basically the right way to regulate the internet because they're flexible and they allow us to move quickly and dispense with legal formalities and all those pesky things. And there's certainly a time and place when those things are appropriate, when they're backed up by real legal merit. For example, saying, we might legislate in an area, right? If there's actually a threat like that, I understand that. However, I I don't see where the line is, and nobody has really drawn for me the line that says what sorts of threats are appropriate and what sorts of threats are not. And it seems to me that there's a serious problem here when you have government agencies who are potentially working with companies that stand to gain a great deal from changes that are made in regulation. Because, Aleecia, it may be about money, but some companies benefit. There are differential effects here, and there are alliances and strange bedfellows with what we call Baptists and bootleggers, who ally to do things that might seem like good things, but they get coerced in ways that are not pretty. So I'm deeply disturbed by this. I'm disturbed by this for the same reason anybody should be disturbed by Joe Lieberman calling Amazon and getting them with no legal authority to shut off hosting to WikiLeaks. And you could say that's just the bully pulpit, he's just exercising his free speech rights. But where's the line? And don't you worry about the road to hell here being paved with good intentions.
I guess in this one-word answer is no, because I mean, I think that some people may not like the fact that there is a government voice on behalf of consumers that is, as you're suggesting, pushing companies to behave in a certain direction. I happen to think when we're in this environment where we don't have clearly established legal rules, we're in that second category of privacy policy, as I suggested. I think everyone, certainly the large companies, go into this eyes open. I think the large companies have made a pretty clear choice for exactly the reasons you suggested, that they're willing to engage in this kind of back and forth. This does involve a certain amount of pressure from regulators, a certain amount of pressure from organized groups, citizens groups in the public. And I think that if they get tired of it, they could just say no, number one, which they've done. Or they could say, actually, what we need is a stable legal regime, and they could go and support a law. And that has happened too in other cases. So I guess I don't always agree with Tim Wu, but I actually agree with Tim on this point, that I think having this kind of flexibility where companies can be pushed to respond to consumer needs in a way that may not happen as a result purely of market pressure, but where we don't freeze rules with legislation that I think you agree, could sometimes be overly restrictive. I'm okay with where we are. If anything, I think, and I do think that it's a particular style of regulation that really the bulk of the industry has chosen and advocates for. So they don't seem to have a big problem with it. I think privacy advocates more often get frustrated that they don't have, a clear avenue. And as I suggested, much of this bully pulpit activity happens based on, the initiative of policymakers. And the fact is, those policymakers are mostly political appointees. They get elected or not. And I'm comfortable that we have enough kind of feedback in this system that I don't think there are any examples that I know of egregious pressure being brought without some recourse.
So I want to call on the guy who I think has a Joy Division shirt on just because it's cool. But Paul told me I had to end because we're running over. Everyone will be available, right? I mean, we have a break. How long is it? Oh, immediately? Oh, I'm sorry. At the next break. So let's thank the panel. And I'm so sorry for calling you.
That was great. A lot of fun.
I'm so sorry for calling you.
Thanks, Steve.
Because I heard you
Yeah, that was great. I sometimes do this stuff for I found the old icon from the
there should be. If after she's done setting up the locker, she can use water.
Hey, man.
Okay.
Let's go.
Yeah, thank you. Yeah, I look forward to reading yours as well. Doing your homework today. Okay. Yeah, how are you? Well, I'm glad to see you again. Good. Chilly outside, but... Okay, yeah, I'll just look for it then.
I'm just going to talk about Hey, good comments. Nice to hear it's going well. I'm going to get a tech person to come down and help with that.
All right, let's get started. Please take your seats. So, welcome to our third panel, Privacy by Design. I'm Harry Surdin. I'm on the faculty here at the University of Colorado Law School, and I have the pleasure of moderating this panel. Let me briefly introduce our distinguished panelists. To my left, we have Annie Anton from Georgia Tech. Next to her is Deirdre Mulligan from UC Berkeley. Next to her is Helen Nissenbaum from NYU. Next to her is Brian Cunningham from Palantir Technologies. And last but not least, Scott Shipman from eBay. There are more extensive biographies in the program, which I direct you to. All of our panelists have very distinguished backgrounds. So this panel will be discussing privacy by design. And for those of you who aren't familiar with the concept, let me give you a very brief overview before launching into the presentation of our panelists. So privacy by design is the process of architecting privacy protections into the very design of technological products or processes. So by way of very simple example, if you are a software engineer writing a web browser like Firefox or Chrome, you have a multitude of choices about different ways to design the software, different functionalities you can implement about what the web browser does and how it does it. Some of these design choices can increase privacy. Some of these design choices can decrease privacy. So your browser, for example, could expose your browsing history to any website you visit. That's one possible design. Alternatively, you could design it to make that private information inaccessible. Similarly, one could design a web browser such that your browser transmits private information in the background without alerting the user. Alternatively, you could design it such that the user is alerted or has the option to stop the information. The major point is that you can intentionally elect from a range of technological designs, some of which can deliberately protect your privacy. So with that background of the concept of privacy by design, let me turn it over to Helen.
Hi, everybody, and thank you so much for including me in this event. It's just to listen to everybody and to catch up on what's going on has been amazing. I want to talk about privacy by design, values in design, but just a little bit of background of some of the assumptions that I start out with, and that is that I understand privacy and the mission of protecting privacy and I'm calling them socio-technical systems, and it's not just the technology. And what I mean by that is that it's an effort to promote appropriate information flows and appropriateness of information flows, and I mean this will be familiar if any of you have read the work on contextual integrity, is a function of the social context, the actors, the information types, and the transmission principles. And the reason it's important to give that as the background is that the technology always sits within a social context. And so you can't take that technology outside of that context, outside of knowing who the actors are and where the information is flowing, and say, oh, this is a privacy-preserving system, because it's only privacy-preserving if we already know that it manages and constrains appropriate flow in that context and between those actors and about those pieces of information and under a particular set of constraints. Now, often privacy by design, when I've heard it discussed, is there's a limit to what it can achieve when it's looking at, for example, within an institution or within a group of actors who want to promote privacy within a certain system. And I think that the panel that we've just heard really was a great setup, if you will, for the discussion that we're having over here, because most of the time we have to implement privacy in a system where there isn't one overseer, one system designer who says, okay, I'm going to focus on this system and I'm going to implement privacy. But rather, most of the time, we're interacting in highly complex informational flows. And there are many moving parts, and many of these moving parts are moving in completely disparate directions. And so it's very difficult to achieve that kind of privacy by design. To achieve it when you have to get all these multiple actors with different incentives, different interests to play nicely together. And again, this discussion of do not track is exactly one such instance. In an effort that a few colleagues and myself made, we learned this lesson the hard way. And I have to say that when I hear people say that if we stop tracking, the internet's going to break, I have to respond and say, hang on a sec, advertising happened before tracking, so there's something we all buy into. But in any event, Agnostic was a little system we tried to build that said, gee, you know, we can do tracking on the client side rather than on the server side, and then we could have targeted advertising, but without the tracking, which is what we're worrying about, at least from the privacy perspective. But the unfortunate part of this was that we had to get a few other parties to play with us in order to get this up and running. We needed people to serve the ads and so forth, and they were not particularly interested, and that more or less fell flat. So this is the situation that individuals often find ourselves in. We're in this dilemma when we're operating with some of the big companies that we've been talking about all the time. We have choices. One is, you know, the suck it up choice. The other one is the, you know, hope for the best choice. And then the one that I'm going to be talking to today in a rather focused presentation is to talk about what I'm calling DIY privacy. What is it? What can we do when we're in this circumstance where we see that the flows are inappropriate, but nobody seems to be doing anything about it? Danny, I would love it if the government would do something about it. It might take too long, you know, for my lifetime. And here we are. So there is, and many of you are of course aware that there are thousands of these. I don't know if it's thousands, but there are many plugins and extensions that are out there and offer this opportunity for DIY privacy. And I want to talk and here's just because I want to give you an example of something very recently that came out of NYU. It's called Cryptogram, and it works for, let's say, something like a Facebook or a website that where you might want to store your photographs. And if you don't want the server to be able to use your photographs, maybe whatever, to train their facial recognition systems, then this will encrypt and decrypt, and this is provably secure. It allows you to enjoy the key photo sharing experience, but it also prevents the server where you're storing this information from doing stuff with your photos that you don't particularly care for. And so this is an instance of DIY privacy, but I want to talk even more specifically about DIY privacy using or with obfuscation. Now, I stumbled upon this strategy when a few of us, and primarily it was me and Daniel Howe, and now Vincent Tubiana is still involved with this, developed a system called Track Me Not, and it was back in 2006 when it sort of became evident to everybody that search companies were maintaining logs of your searches and that nobody really knew what was happening with these searches. Many of us became very concerned about this, and even those searches that were supposedly, the logs that were de-anonymized were able to be, the searches were enabled, could be re-identified. And so we developed this product called Track Me Not. It's a lightweight browser extension. It works with Firefox and Chrome at this point. And what it does is it generates search queries. The Track Me Not generates search queries, and in so doing, it obfuscates the user-generated searches. So that was an effort to, you know, I can't wait. I'm going to take matters into my own hands. And it's very easy to install. We have stopped counting how many downloads, but it's in excess of 1 million all around the world. It's quite expressive. And at the time of seeing how it was working and how easily people could implement it, there was a sort of aha moment that I had, which is, you know what, yes, of course, you can protect privacy not by only withholding information, but by actually flooding people with information. And this is what I mean by obfuscation. And now working with Finn Brunton and various other people, we're developing this concept of obfuscation. We're trying to understand what are the circumstances in which obfuscation is the solution to a privacy problem. So the definition that we have of obfuscation is this: the production, because obfuscation is just an English word and it has historical meanings, but our definition was this particular one, which is inclusion, addition, or communication of misleading, ambiguous, or false data in an effort to evade, distract, or confuse data gatherers, or to diminish the reliability and value of data aggregations. So this is how we use obfuscation. And for those of you who like to picture things visually, this is the definition of obfuscation. And some of you may have seen this movie, A Few Good Men, in which Demi Moore and Tom Cruise are trying to defend some guys against a murder charge, and they ask for some documents, and they arrive in their office, and there are boxes and boxes of documents, and yes, of course, their request was complied with, but obfuscated. Now, in looking at obfuscation, we found, and I think maybe you would agree, that obfuscation is a very natural way to protect yourself against information about you leaking out in ways that you don't particularly want. And so we looked historically. Finn Brunton is a historian of science, and we found that there are lots of different instances of obfuscation. And in the interest of time, I'm not going to go through all of this, and perhaps you're reading some of it already. I'll just mention the Craigslist robber. How many of you know about it? A guy robbed a bank. He did it with a gas mask and wearing an exterminator outfit. And as he was leaving the bank and the police were trying to chase him, all of a sudden, hundreds of people showed up to the scene wearing gas masks and blue exterminator suits, and he got away. This was in Monroe, Washington in 2008. There's the loyalty card swapping idea, the yellow Star of David, which is actually not exactly true, but the idea is, you protect a population by this method of obfuscation. Selective obfuscation is when, you would publish a lot of material, but only selective individuals would know which is true. Track Me Not is one. Cache Cloak is a really interesting one, because what it allows is, it's for location-based services where a user doesn't necessarily reveal his or her own place, but rather asks. So Cache Cloak will request from services information for numerous, it's a little bit like crowdsource, but use lots of different locations, and then it's on the side of the device that the device can pick out the information that's relevant to them. Now, there are many challenges, and these emerged as we were moving along with Track Me Not. Many of these are scientific challenges that challenged whether it works. Our conclusion about it was that obfuscation and, for example, Track Me Not, it's a good enough defense. Its success is multidimensional. It depends on what your goal is. For example, is it just to obfuscate for a moment while you get to do what you want to do? How much resources does the adversary have? And what sort of vulnerabilities are there to these side channel attacks? Now, the ethical and political challenges were also considerable. Questions of, you're lying, and that's bad. Maybe there's a waste of resources, you're polluting the stream, you're damaging systems, and so forth. Now, these were all, and I could go in more details, but I want to just push again to my next slide, which is the final slide. But what we found was that once you establish, and this makes a difference, that the ends of the obfuscation are morally legitimate, that you have not given users alternative means to achieve the ends they want, either through regulation or through corporate best practices or whatever it is, that there are significant asymmetries in epistemic asymmetries, and some of this we've already talked about today. Epistemic asymmetries, power asymmetries, and this is quite important, asymmetries in risks and benefits. Once you've established that there are these asymmetries, that the ends are legitimate, and that there are no significant alternative means then you have a circumstance in which you can justify the obfuscation, and we arrive at a situation of a clash of interest. The data collector wants to collect the data. The subject says, no. Obfuscation, we argue, is appropriate at that stage. Now, and so we've labeled this a weapon of the weak. Obfuscation is a weapon of the weak. It's relatively easy to do. It's inexpensive. It's good. It's great. It's not necessarily perfect, but it's good enough, and so on. We still have many challenges, and this is my final slide. There are the engineering challenges. There's statistical studies that we have to do. There are questions of social science, social scientific questions, and politics. But what's also important is that obfuscation, like track me not, can work when you have things like open access to protocols, open access to systems like Netscape, Mozilla, and some of the closed systems, unfortunately, will reduce the possibility of doing this. And then finally, we need to make sure that on the policy level, we place limits on enforceable terms of service. Thank you.
Thank you. It's a very interesting presentation. For a brief response, I turn to Brian. We'll have more of an opportunity to discuss all the presentations during the open discussion. Brian?
Thanks. So let me say first that I'm not an academic. I'm a practitioner, and I'm not an engineer. And most of my experience has been in developing privacy protective technologies in an arena of software to analyze big data in government context. So if you think about a Venn diagram of what this conference has talked about, in my experience, there's nothing in the intersection. So, so I'll be as brief as I can. But in my defense, I am a CU alum, and also I was the Craigslist robber. So I just want to make 3 quick points, because I was a political science major, and we always make 3 points, whether we actually have them or not. I found the paper on obfuscation, Helen's paper, really interesting. I recommend it to everybody. My feeling is that this is an example of a set of different types of technologies that I've started thinking of as, in effect, self-defense or self-help technologies. Helen calls it do-it-yourself. And the underlying assumption, I think, in all of them is that the system, whether it's the government or whether it's the whole other suite of security tools, antivirus, firewall, et cetera, either will fail to protect your data or it will be bypassed in the case of a government demand for information. So therefore, you need to basically take matters in your own hands. Danny talked earlier about a world in which individuals go find their own munitions as they can find them. And I think suggested that wasn't a world that we wanted to live in. But in any event, there's a whole emerging set of these tools, which obviously include strong encryption where only the user has the keys. One that is a little bit off as an analogy, but my teenage daughters just showed it to me, so I find it so interesting I have to mention it, is Snapchat. I don't know if anyone has seen Snapchat, but basically what that is if you want to send a photo or an SMS message to another person, you put a Mission Impossible style time bomb on it. So the picture goes to the other person, they have 5 seconds or whatever you say they have to look at it, and then it goes away. Now, I don't know how much it goes away. I don't know if it's sitting on a server somewhere, maybe some of you guys do, but I think there's a fundamental difference, though, between most of these self-help or DIY tools and something like obfuscation, and that is, with most of them, at least the ones I'm aware of, you may be denying the internet, the system, everybody out there that wants to see your data, you may be denying them data as a defensive measure, but you're not introducing into the system false, misleading data, which could have lots of other side effects to that. And so first and obvious point I want to make is that, like any other tool or weapon that's ever been invented, it could be used equally by bad people to do bad things as it could be by good people to protect their privacy. And obviously that doesn't suggest that you shouldn't develop these tools or they shouldn't be built, but it does suggest, I think, that people who are involved in building and deploying these types of tools need to just think through what the potential good and bad uses are, and of course we'd all have our different definitions of that, as they're building the tool, and I would suggest try to build them so they favor less destructive uses rather than more destructive uses. The second point, which is related to the first, is beware of unintended consequences. Helen's paper on obfuscation does a good job of showing some of the major beneficial aspects to society of big data and of having certain types of users have access to big data. An obvious one is in epidemiology. If you introduce into the system a lot of obfuscatory data, at some point do you reach a point where those types of positive uses of big data are no longer possible or are impaired. And the potential harms, I think, come in two forms. One is the potential harm directly to the user. So if I decide to introduce a lot of false data about myself out there into the world, there's going to be, I think, a lot of unintended consequences to me personally of that. Am I not going to get the targeted advertising I want? Are my friends going to be unable to find me reliably? Am I going to get am I going to apply to it for a job someday where they're trying to vet me through my Facebook posts or my other internet activity, putting aside whether or not that's legitimate or legal? It's done by employers. Am I going to hurt myself in terms of getting a job? Am I going to not be able to get credit the way I want to? So I think there could be that sort of harm that should be looked at. And then the second one is the one I referred to just a minute ago, which is the more societal harms. And I tried to think through a metaphor of this myself, and the best thing I came up with was the notion, was comparing it to antibiotics. So, I don't know if any of you have kids, have noticed that doctors have become increasingly reluctant to ever prescribe your kid an antibiotic. They'll find any reason they can say not to give your kids antibiotics, except for this year in flu season. And the reason for that is because they're concerned that eventually so many people will become, there'll be so much antibiotics in the system that the bugs, the germs will get immune to them. And I thought that was kind of a good analogy for this, but much better, I think, and more effective are the concrete examples that are in Helen's paper, which she didn't mention. I'm going to just mention one, and that is this notion of quote stuffing. I'm not sure this has been proven, but there's a theory that big-time volume traders on Wall Street have started kicking out automatically massive numbers of requests for information for trading. I'll probably get this wrong, so if it comes up in the Q&A, you can correct me. To confuse their adversaries, to slow their adversaries down enough that they get a trading advantage. Well, at some point, you can imagine, and the paper talks about this, that could get to a tipping point where you actually start to damage or destroy the market and the certain aspects of the economy. And again, this is not a reason, in my opinion, not to develop these tools and not even to use these tools as an individual. But I think it is to say that the scientists among us, of which I'm not one, would be serving a great benefit to start and try to look ahead at these types of tools and imagine, if they're deployed at sufficient volume, what are the kind of unintended consequences that we're not thinking of, and what are the, if you will, canaries in the coal mine that might tell us when we're coming to some kind of a tipping point. And then finally, and there's a good discussion, I think I mentioned this before, there's a good discussion in this writing about the ethics and the politics of tools like obfuscation as well. But the last thing I want to say, which really doesn't flow much from your work, but I've seen others do this week, so I'm going to just throw out my own plug, and that is, although I think it's in there, and that is, I believe there is still, as somebody who has to try to translate laws and regulations into actual privacy tools that are built into technology, there is still a huge disconnect between what legal scholars do, what policymakers and regulators do, and what engineers actually have to do on the ground in building technology. And our company, Palantir, actually created positions called Civil Liberties Engineer, which one of my colleagues is here, has that job. And their job is to try to work with privacy groups, look at the legal and regulatory requirements, and then actually go back to the engineers who are iterating software every cycle and try to explain to them how you want to build privacy protections and at what stages in each one of the processes of building the technology. So it seems to me there's a lot of very useful work to be done in what I would call gap analysis. So lawyers, policy people working with technologists and engineers to look at workflows for various types of activities. In our case, intelligence officers or police officers trying to build cases. But I think you could make the same type of analysis for social media users or commercial data or whatever. What are the points where it would be useful and beneficial to insert privacy technology, and what kind of technology do you want to put in those points? And the lawyers don't have to really even understand if the technology is possible or how to build it. They just have to be able to communicate to the engineers where to intervene and how. So that's my shameless plug, and I'm done. Thank you.
Thanks, Brian. So let's turn it over to Deirdre, who has her presentation.
I think it's on your thing, yeah.
Is this one hooked up?
One second.
This one, yeah. The other end.
This would be a good time for engineers to talk to lawyers.
The Mac user here is admitting that I don't. And you're going to time me, so I don't
Yes.
run over, right? Great.
Yes.
Okay. So I'm really happy to be back here, and very happy to follow Helen and Brian's very astute comments. So I'm going to talk a little bit about some of the current limitations in privacy by design, and I want to talk specifically about two problems. One is what I'm going to call limited conceptual breadth, which is too few privacies. So regulators, when they talk about privacy by design, it's more so, I think, in Europe, but I would suggest even here, equate privacy by design with adherence to fair information practice principles. And these are principles which I'm going to assume most of you are familiar with, that have been around for a very long time, and I think are a very good tool when we think about government collecting data from citizens, or about a company collecting data from citizens. I think they are much less useful if you are designing a standard or you're designing a social network system that is going to enable individuals to interact with each other or to form communities or to share information, that they don't resonate because we're talking about different kinds of privacy. Privacy is a term with many meanings. The other forms of privacy that we see come where there's a fair amount of research in the technical area about what privacy means that's relevant is in the field of HCI, and there we have two different theories of privacy that animate their research and some of their design directions. One, again, is this privacy as control. Individuals ought to have control over their personal information. The second is this idea of privacy as a negotiations around boundary regulation, and you'll see that in somebody talked about a Facebook tool earlier that allows you to see yourself as others see you, right? And that's an effort to help you understand the way in which you're constructing boundaries around different segments of your community. Those are the sorts of tools that we see. However, as Brian just noted, there are insufficient tools, right? In the control area, we have fair information practice principles. Here, engineer, take these principles, please go and implement them. We have things like privacy impact assessments, which the Department of Homeland Security and other parts of the US government and in other countries, regulators also require people to use to try to evaluate the privacy impacts of a given technical or socio-technical system. However, they are not tools that engineers use to build systems. They are not like software design patterns. They are not things that if you go to an engineering school and you say, hey, have you tried using this to design an app? They look at you blankly, right? There are things, such as the work that you're going to hear about from Annie, on requirements engineering, which are very, very important contributions to privacy by design. However, they are about taking a law where we have decided what form of privacy we want and trying to translate it into a set of technical properties. That is not what regulators are necessarily talking about when they talk about privacy by design.
So privacy, it's a morass. People have talked, sorry, I didn't mean to go forward. When we hear people talk about what privacy is, it comes from some of my very favorite comments, such as, from some leading scholars, few values so fundamental to society as privacy have been left so undefined in social theory or have been the subject of such vague and confused writing by social scientists. The most striking thing about the right to privacy is that nobody seems to have any very clear idea what it is. It's a concept in disarray, right? This is what you hear about privacy. We have privacy as limited access to the self, privacy as control, privacy as freedom enabling, right? What's the justification? It's about self-development. It's about intimacy. It's about zones of control related to property. It's about, again, sociality theories about limiting access to the self because we want to allow people to develop as individuals so they'd be better participants in society. Privacy tends to be portrayed as this black box. What I want to suggest is that privacy isn't a black box. However, it is what is known as an essentially contested concept. What does that mean for us? Well, an essentially contested concept, this is a term developed, authored by Galley in 1956. It's a concept, the proper use of which inevitably involves endless disputes about their proper uses on the part of their users. And these disputes cannot be settled by appeal to empirical evidence, linguistic usage, or the canons of logic alone, right? Words like democracy, truth, right? That these are terms, they do incredibly important work in the world, right? And the fact that they're contested is actually really important. Privacy has benefited from its contestability. It means that it's resilient, it means that it's generative, it means that it can be contextually deployed. However, it also means that it's slippery. We can deploy it in very sloppy ways. People say, oh, the introduction of video surveillance in a public place, it's an assault on my privacy. And you're like, well, what do you, other people say, well, what do you mean? You're in a public place, right? And you don't actually have a good conversation. You have this rhetorical debate. It can also be decried too fickle, right? You'll see people who do engineering, they're like, well, I can engineer security, but privacy? I can't possibly do that. It's too personal, it's too fickle. So what do we need to do if we want to address both the benefit of this contestability, or what I'm going to say, all of these various meanings of privacy, but address the fact that working with those many meanings of privacy can be really quite complicated, particularly if we want people who are not lawyers or social scientists or philosophers to deal with them. So I want to say first, we need to embrace privacy's plurality, right? We don't want to essentialize privacy. I don't want to end up with FIPS as the only operative definition of privacy to animate design, right? Privacy is boundary control, privacy as contextual integrity. We want people to be able to work with varied concepts of privacy because different concepts of privacy are going to be effectively deployed to address different sorts of problems. However, to do that, we need tools to help people work with those multiple concepts. We want to leverage the power of this multiplicity. So I have one partial response. I've been working with a colleague, Colin Koopman, on a multidimensional privacy analytic. And what it's attempting to do is provide a thick description of privacy. If we have many meanings of privacy, that's all fine and good. How do those meanings actually relate to each other, right? What sorts of objects? What are the objectives? What are the justifications? What are the targets of protection in different theories? The goal is to reveal connections and divergence across theories. More importantly, I think, for this particular conversation is to enable descriptive and prescriptive work, both understanding privacy problems and designing privacy solutions, whether it's through law or technology. I don't have time, obviously, to go through some of the dimensions that we have included in this analytic. But in the theory section, just breaking down, what is actually privacy trying to provide? Is privacy about dignity in this theory? Is it about control over personal information? Is it justified based on individual liberty? Or is it based on social welfare? Is the contrast concept, which can often be really important, is privacy the opposite of public, or is it the opposite of open or transparent? I'm going to skip through. And then on the practical technical dimensions, if you are somebody who's trying to analyze a privacy problem, well, what was privacy actually trying to protect? What was the target of protection? Who was the subject? Who was supposed to be protected, right? So to provide an analytic that helps people work through privacy problems. I want to take 2 more seconds, I promise not 2 whole minutes, and just to use a particular example. Are you familiar with the introduction of Newsfeed at Facebook? Okay, so if you remember, when Newsfeed was introduced, they didn't actually change whether or not you had decided to share information with any given person, right? And so when they came under fire, Facebook's response was, well, we didn't change anything, right? Because they hadn't changed the policy that it afforded individuals control over to whom they disclosed information. What they had done is shift the mechanism, right? Not the policy. They had shifted the technology. What had happened is we went from a pull mechanism where if somebody wanted to see your data, they had to come to your Facebook page. Now it was being pushed out, right? So the comments, the critique from users, some people accused their friends were stalking them, right? Which at some point you're like, you chose to share information with friends, we made sure they saw it, and now you're telling us they're stalking you? Like, doesn't make sense, right? If you're thinking about control over the personal information. On the other side, users said, I'm spamming my friends, right? And now that doesn't sound right either, so that the privacy interests were not just about the individual who was disclosing information, maintaining control over it. It was about the shift in this structure, right, in this mechanism, this technical distribution tool. But if we think about privacy just as accordance with fair information practice principles or something that's just about policy, we lose the fact that the mechanism that was important here was actually the technical mechanism itself. So those are the goals, and I'm going to stop there.
Great, thank you very much. That was very interesting, and I want to follow up on that. So for a brief response, let me turn it over to Scott.
Great, thank you very much. And we've got a solid, strong room of intelligent minds here, and I think that one of the things that I was most delighted to see with Deidre's research, I actually had the privilege of reading the 46-page draft, which I really like the framework that she's mapped out. I want to step back a second because we've had a wonderful day so far, and there's been a number of themes that have all been real similar and coming together. And so I've got 3 questions. The first of the 3 is, what are we really talking about? We've had do not track, we've had technology, we've got FIPS are good, but we need broader concepts on how to think about privacy. We've got, well, the industry has failed from responding appropriately. We've got regulators in the wings, waiting to jump in if business should fail, which we've heard has. And so we've even heard that the internet wasn't designed for commerce. From an eBay perspective, commerce is working pretty well. Payments is working pretty well. And in fact, eBay is a very trusted brand with respect to privacy. So what are we really talking about? First-party relationships? Third-party relationships? Unknown relationships where I'm being tracked? And I think the framework that she provides is a good way to evaluate in each of those areas. How do we evaluate privacy? In a first-party relationship with a service, in a first-party relationship with social networking, in a first-party relationship with search, in a third-party relationship with search or browser technologies or advertising. So I think that's something worth thinking about, because as we feed into my second point, which is, where are we in time? I think a number of people have implied that we are at the edge of the privacy cliff, that there is this sense of urgency, that consumers' rights are being ruined every day, that privacy expectations, whether it's this one or this one or this one, are already over, and that we've messed up. Or are we really at a moment of time where there's a lot more time? And depending on how you look at that framework and the groups that you're evaluating, I think that moment in time is either really small or really big. And so that's another component that I would urge us to look at. And then my third point is who's responsible? And many people typically have an immediate reaction to who's responsible. Business has failed. Business didn't come up with a do not track or a short form for privacy labels on mobile, or a label for short form on the web, or maybe lawmakers are responsible because they haven't come together and passed a law, or W3C is responsible because where have they been for the last 10 years? And great, they're coming back, but now what? And again, the framework provides a really nice way to look at each audience and who is appropriate to evaluate the privacy norms within that audience. When we look at who's responsible and we look at where we've come from, I'm implying that there is less urgency around this. Do not call, can spam. We have financial, health, and children's regulations around privacy. Do not track is all over the place. State security breach, state privacy regulations. That's quite a response from our regulators and our legislators. They've not been doing nothing, they've done a lot. When we look at FTC, we have a clear string of actions, all prescribing and encouraging certain types of actions and behaviors. They've clearly not been sitting on the sidelines. And when we look at businesses, we have all kinds of innovation that's been happening. You can go back, and here's my shameless plug, you can go back as far as '99 and look at PayPal. And the fundamental concept of privacy by design, before privacy by design was bandied around as a phrase, they allow you to purchase an item without sharing your credit card information with the merchant. You don't have to worry about someone walking around the corner of the restaurant, writing down or swiping or sniffing or scanning your card, because the merchant doesn't receive the information. So fundamentally within the system, privacy was built in by design as a market differentiator, as a competitive advantage. Today we see companies competing in a host of areas on privacy. And so who is responsible? I think we've got some clear groups that are, and I think we've seen a number of wonderful reactions as a result.
Great, thank you. Next we have Annie Anton. Yeah. Security by design.
Good afternoon. So it's been a very interesting discussion and all these great segues to what I'm going to chat with you about. The session was, I understood, was values in design and privacy by design. So I thought I would first take a look at how our privacy values have evolved. So first, you may remember, some of us are old enough to remember this. No one knew you were a dog on the internet. But then, not only did they know you were a dog, but they knew what kind of dog you were, and that you had a crush on the third Lassie, and you downloaded a bunch of Lassie's photos, and we know who you emailed it to, right? And now, cool, I just sold a dog on eBay. Same with cats involved. But online, how do we assure the public about what we're concerned about? So some of you may have seen this before. Congratulations, Dave. I don't think I've read a more beautifully evasive and subtly misleading public statement in all my years in government. And that's probably how you feel when you read a privacy policy. And there was some discussion about this morning, about like, are they really readable? And we've done some work on that in the past, but I wanted to focus on our analysis of end users' privacy values. So in 2002, Dr. Julie Earp and I at NC State ran a survey, and what we found were that the three things that consumers were most concerned about online were information transfer, notice and awareness, and information storage. And then we also did a content analysis of many, many privacy policies.
And what we saw that they emphasized in the body of the policies was data integrity and security, information collection, and user choice and consent. So there was this clear mismatch between what people cared about and wanted to see in policies and what the policies were actually emphasizing and expressing. So we looked in 2009 and 10, we decided, let's redo the study. You know, we now have all these data breach notification laws. We were just wondering if anybody had, people were changing their views of privacy online. And so the little red dots are different states when they introduced their data breach notification laws, and the blue spots were all of the reported data losses. And you can see people start reporting a lot more. So we reran the survey, and what we found is that people are still concerned about the exact same things, and their value is still value the same things. So what changed was their level of concern within these categories. So we found that people are now more concerned about disclosures of their purchasing patterns and more concerned about trading and selling of their information to third parties. They have a stronger desire to be notified about security safeguards, but they're less concerned about options for how their information is going to be used or changes in privacy practices, probably because they get a new one from the bank every week. They are more concerned about websites that are recording information regarding the site that they came from previously. Okay, so do they like to be tracked? Doesn't sound like it. Then we also looked, this time we had enough responses, international responses to compare US versus non-US, and there was just one little switch in what was most important. So information storage and notice and awareness were different, but you see everybody's still concerned about the top three things. So that's what I'll say about privacy values. And then when we talk about, Deirdre mentioned I come from a requirements engineering background. So for us, when we talk about privacy by design, we're really thinking about how do we satisfy the specification? What do we need to comply with? And so that is how we have sought to achieve regulatory compliance. And the challenge is for software engineers is you specify requirements, you deploy the system, whoops, data breach or legal problem, and then you have to go back and say, oh wow, there's some law I wasn't complying with, and you have to figure that out, you codify that, you refactor the software, etc. So the best practices is to use the laws initially when you're trying to specify your systems. And so for us, that's what we think of when we talk about privacy by design. The challenge for us as software engineers is that it's really difficult to understand law. So there's a lot of cross-references. There are ambiguities, there are exceptions, there are conflicts, which when folks are writing these laws, they really just don't think about it and don't think about disambiguating and deconflicting things as much as we do as engineers. So we need to provide guidance for software engineers, and that's what we've been working on. And our goals for compliance are to ensure that we can prove due diligence. So let's say we develop a software app and there's a problem and there's a breach or there's we get attacked in some way. As long as we can, the lawyers that we confer with have emphasized that as long as we can show due diligence and show how here's the law, here's the requirement, and here's what we did to satisfy it, and something else beyond our control happened, then at least we can prove that we have due diligence, that we've adhered to a standard of care. So that's the goal that we have. And so I only focus on two of these, but there are a lot of factors that make legal text difficult for us as engineers to understand. One are the immeasurable number of cross-references, both internal within a regulation and external to other regulations. And also just ambiguities, which are some are intentional and some are unintentional. So here's an example of an ambiguity. An intentional ambiguity is that will protect against any reasonably anticipated threats or hazards to the security or integrity of such information. So one would assume that, well, we don't know what reasonable is yet, and reasonable might change over the course of time. But then there are language ambiguities, like the covered entity must promptly document and implement something. Well, promptly is just horrible for an engineer because we want to know how promptly, because every requirement you write has to be testable, and promptly is not testable. Right? So there are things that we can do in law when we're writing it that can make it a lot easier on the engineers to actually comply with the law. One of my students, Jeremy Maxwell, did this work with Peter Swire and I actually, where he analyzed all of the different cross-references that were in the HIPAA privacy rule. And so we were looking at the internal versus external privacy cross-references. So we decided to focus on external cross-references to see if we could decide whether there was a taxonomy of the types of cross-references, whether there's some techniques we can use to identify conflicts, and just tools that we can provide to software engineers who need to be able to comply with these regulations. So this shows how complex this is. These are the cross-references from HIPAA to another regulation. And you, the lawyers, want us, the engineers, to figure it all out. And it's a challenge. It's really, really difficult. Unfortunately, a lot of software engineers will say, oh, well, we just assume all the cross-references are true. Well, you know what? That's where we're skipping some steps and problems can happen later on. Okay, so who's responsible for that? I would argue that as software engineers, we have a professional responsibility to try to be complete in what we do, but it's very difficult. So we found, I won't go into a lot of detail here, but we have a taxonomy of the types of cross-references. There's a paper on it in the IEEE International Requirements Engineering Conference in 2011. These are the types of reference types that we were able to find in the HIPAA privacy rule. So I mentioned it's important to be able to find conflicting requirements. So here's an example of one of the conflicts we found. So the HIPAA privacy rule says you keep PHI for 6 years after the last use. And the Privacy Act of 1974 says keep for 5 years or for the life of the record. And it's little things like this that drive us as engineers kind of like batty because well, what do we do? We call the lawyer, but we need some kind of guidance, and it'd be nice to not always have to call the lawyer when we're doing things. So we developed a bunch of strategies for how you would address conflicts and different things that you would find in law. I'm only going to focus on 2 of them. One of them is to have a policy complying with the restrictive law. And so we have a ceiling rule or a floor rule, and you can resolve according to this table depending on what you decide to do. So you either consult a legal domain expert or you comply with a shorter time, for instance. Another thing is that we just have to consult legal domain experts at times. So some conflicts can only be addressed when we talk with them because we don't have the expertise to do that or the understanding of the law. I won't go into this, but this is the paper has a lot of interesting examples about conflicts that are identified. And then I'm going to finish by talking briefly about a study that Aaron Massey did. Aaron's here today. He did this as part of his dissertation work. We did an empirical study looking at whether software engineers, particularly graduate students, could decide whether a software requirement was legally implementation ready. And so here's an example of a legal implementation ready requirement. This is for an electronic health record system. So the requirement on the left is iTrust shall allow an authenticated user to change their user ID and password, but that would be a conflict with this on the right, where you have to assign a unique name or number for tracking. So you would have to change that requirement in order to comply with the law. So these are the kinds of requirements that we gave to the students to see, and then the relevant portion of the law to see whether they could determine whether the requirements satisfy the law. So there was 31 requirements. Aaron has also developed some metrics that we can use to try to do this in an automated fashion, and we used one section of HIPAA that focused on technical measures of protection. And so what we learned is that the graduate students really were very ill prepared, and they'd had it was a course on requirements engineering. We'd had several weeks on compliance, on law, on policy, and they still had a very difficult time with it. We had 3 experts also do it. One of them was a lawyer. All 3 of us are software engineers with a lot of expertise in analyzing regulations and policy. And we use a wideband Delphi approach, and so we were able to reach consensus on all but 2 of the requirements. So we performed pretty well compared to, a lot better actually than the students did. And then the students actually did a little better than the metrics. And so we're working on the metrics now to improve that. But I just wanted to give you like 3 different slices of how we've attacked this problem. One is looking at privacy values and privacy policies. Another is trying to figure out how do we codify law so that we can build software to comply with it. And then the next component is that how do we train software engineers to be able to do this? And it's a really challenging problem. And so just as a final recommendation, I think it's really important that the people who are designing your systems understand the laws and policies and that they can assure that they're compliant. And it's really difficult to support ambiguous legalese. And so anything that those of you who are students who may one day be the ones who are writing law, to consider trying to disambiguate as much as possible so that you're helping the software engineers develop software that complies with your goals and specifications. And that's it. Thank you.
Great. Well, thank you, Annie. Let's have a round of applause for our presenters. So thank you for confirming what I always thought. So I used to be a software engineer, and now I'm a law professor, but I like to say it's the same job. I spend my days looking at hundreds of lines of unintelligible code, so you seem to have confirmed that. So tying together some of the themes that we've heard so far, I want to throw out there, based upon Deirdre's work and Annie's work and Helen's work, whether we have some conflicts here in the fundamental idea of privacy by design. So on the one hand, whenever we're designing privacy intentionally into technology or into a system, we're making value choices. And Annie has raised the point, how do we find out what those values are? And more importantly, whose values do we choose over another? And I think Deirdre even raises a more fundamental point is, do we even have the analytical tools to be making these privacy value choices competently? If we can't even distinguish privacy interests that are analytically distinct but superficially appear to be the same thing, are we going to be creating more harm than good when we're making privacy choices? So I want to throw this out to the panel and hear your responses.
Who wants to start?
Yeah.
Well, the question is, do we have the competence? The answer is clearly no. I mean, it's like writing the Italian Constitution, right, which has been amended like 197 times since 1945. If you try to write sort of permanent fixed rules that can be used across all these various different applications and technologies and business areas, that seems to me to be a losing proposition. But I would also say we probably don't need to have that competence, because there's been lots of other problems like this in all of legal history, I'm sure you law students know well, where there are standards that society wants to be set, but there's no way a legislature or a judge at a particular point in time can ever predict or keep up with developments in technology or society or whatever, so you set pretty basic level rules, and then the law develops the specific rules as it goes on. So I don't think it's as hopeless as, you know, maybe the sum total of everything we said before makes it sound.
I don't want to pick on technology, so I'm going to pick on law. And yeah,
Safer.
Well, probably for me to pick on law. Yeah. There's really, really good examples of how a lack of an analytic for privacy has led to really crappy statutes, right? Or statutes that don't age well, and I'm going to pick on ECPA, which is so the Electronic Communications Privacy Act, which most people in the room are probably familiar with, was designed at a time when the kind of dominant uses of the internet were to either send your data off for remote processing or send email, which was left potentially on the server until you downloaded it. And then if it was left on the server after that, it was because you intentionally kept it there. And so we had this suite of privacy protections that were put in place that made two assumptions. One, that the dominant way in which we were going to use the internet was to communicate in a way that was relatively private, and so it would be like first-class mail was the analogy that was used. And so the outside of the envelope was stuff that had a very low privacy concern, i.e. all the information about identity and where it was going, right, all of the routing information, and what should be kept really private and what we should have more stringent rules was the content. Well, fast forward to today, and we live in a world where people are posting the content all the time, and what they want to withhold is their identity, right? And so because we didn't have a privacy analytic to inform the drafting of the statute, we decided to rest on an analogy. And the analogy that we took, tied further to the particular design of the technical system, was perfectly fine for the privacy risks at the time. But they didn't age well because they were so tethered to a particular use of the technology. And nobody said, well, how might we be thinking about using this new platform? What sorts of privacy interests? Well, we really care about identity, and anonymity is very important to freedom of expression. We're really concerned about freedom of expression, right? But we didn't have an analytic to drive the discussion about what the statutory framework, so we rested on the particular example. And law likes to proceed by examples, but examples in the absence of an analytic, I think, is really risky. And I think we've seen an evolution in security, right? If you're a technical person, where you have a particular way in which you think about information security, right? And you have tools that help you do threat modeling. And those things are really, really important because they bring a level of rigor, whether it's you're designing a technical system or evaluating a technical system, or you were designing a law. And I think we really need that in the privacy space.
Yeah.
I echo her comments.
Okay.
We had a conversation last night, and it actually connects up with some of what was said today, which is that what the technology design often forces us to do is evaluate what we meant by the value and why we are interested in promoting it. So we might think that ECPA was a mistake, and clearly ECPA does need to be reformed.
It was a good statute. I just said it didn't age well.
It
was
didn't
not a
age
mistake.
well. But sometimes we rely on certain aspects of the material world to automatically have the values designed in that we want to have. And then when things change, we realize that the change has suddenly left us vulnerable in areas of life that concern us. So I think that one of maybe a little bit easier case to think about is, say, voting technology, and how going from one mechanism of voting to another mechanism of voting suddenly forces us to be very explicit about how we want to design it. And when we're being very explicit about how we want to design it, we realize we have choices, and we actually need to go to these contested concepts like democracy and say, if we do it this way, is this really democratic? Or if we do it this way, is it really democratic? And you find yourself having to push all the way down to the very value itself. And so, I mean, this is just a rumination, really. It's to say that the design activity is a way to even discover something about the value that we may not have known before.
And this is sort of a follow-up question. I address this to Helen and then to the group generally. Is so often, as you said, emerging technologies will unlock novel possibilities that were just simply infeasible in the past, and we have this activity that's completely unregulated that was at least implicitly regulated in the past. Do we have a principle by which we should seek to replicate the privacy interests of the past? Is there a status quo preservation principle?
Well, I mean, within contextual integrity, there's an approach to it, which is to say that what are the values, ends, and purposes that you're trying to promote in this, even though there would be a change, does the change at the activity, at the flow level, we acknowledge, but then we have to move beyond and say, what is it in this picture of moving parts that we want to hold fixed, and which are we willing to let move? Now, I'm sure that there's a lot more to the story than that, but at least there's a criterion for evaluating some of these changes?
Harry's being a very modest moderator, but Harry's paper about structural rights in privacy, did I get the title right?
Yeah.
Is a really, really excellent examination of what happens when aspects of the material world that created a bunch of transaction costs that acted as de facto privacy protections are removed. And this question about whether or not we should assume we should slip policy in right away is a really important question to ask. But I think the more important one, almost, right, the first question is to say, oh, well, it means that we shouldn't, when somebody says, well, you're asking for new law, and you're like, yes, but I'm not asking for a new protection, that it's just that there was a different mechanism that used to provide that protection. And I think, your article makes that point really well. Whether or not the answer is yes, we should slip policy in, I think is a complicated question, as Helen said.
Scott?
I love the analogy to voting because it's primal, and there are clear benefits to technology in voting, enabling so many more people to vote in a much more effective and efficient means via technology versus imagine the truly anonymous lot casting technology of the past that took forever, and boy, you need a lot of little ceramic things to cast. The challenge is also, I think, readily available in the analogy, which is with that technology there are unintended or unanticipated consequences. And so when I look at ECPA, I remember a law professor of mine saying, anybody that tells you they know ECPA is lying. And this was when it had just been passed. And so imagine how we feel about ECPA today. To me, the salient point is we are in an era where technology continues to evolve and bring wonderful advantages and democracy to people. And we need to take the time to look at, within law, the unintended consequences, what needs to be revised. Within technology, the unintended consequences and what needs to be revised. And just one physical observation, when Deidre was saying we need to slip in the law or slip in a regulation. Interesting, though, from a physical embodiment perspective, she did this, right? So there's a perception when we're talking about law and regulation that it doesn't always just nicely slipped in. It's a forceful fist, as I think you probably unintentionally, gestured. And so, again, these unintended consequences of slipping in things can really create some problems.
All right, so I think at this point we should open it up to the audience for some questions in the last 10 minutes. And if we could get a student to volunteer. I know we're making the students work pretty hard today. I do see students in the audience, and I would prefer not to cold call on them.
But you will.
But
I'm guessing my wife has.
okay, yeah, based upon that smile. Thank you for volunteering, or as they say, being volunteered.
So for terms of picking values to include in these designs, what level of competency do we believe that the general public has, and is it increasing at a rate fast enough to really understand where the values lie in their personal policy beliefs, especially with the new internet tracking and things like that? Do people understand on a general consensus what's going on, and is that education or understanding increasing at this point in time, and how fast?
Annie?
So I guess I have a very simplistic answer to this, which is that we were thinking that people's values would have evolved over the course of time, because when we first ran the study, my dad had just started getting online, and there were people who really didn't understand things, and we didn't really understand this world of privacy policies. And yet what we found is people really just care about the same things, and they're still not getting that information in privacy policies. It's really, for me, it seems pretty simple.
Can I say, I think there's another part to that question, though, that's almost never captured in surveys. Just because I get a phone call and I'm given a list of things, or I'm asked what I care about and I make a list, doesn't necessarily mean I really care about them. If I really cared about them, I might go into my browser and take some steps to protect them. And so I think you have to also take into account how people are voting with their mouse as opposed to just what they say in response to a survey.
So it sounds like, right, maybe our techniques for revealing what people's preferences are need some development as well, to some degree.
So that reminds me of another study that one of my other students did, Matt Vale, where he actually did an experiment where he showed people 4 different versions of the same privacy policy to figure out which ones they understood the best. And I'm probably, I haven't looked at this in so long, I'm going to try to remember it, but I believe what the current way of presenting privacy policies, these not long monolithic documents, they really didn't understand them. And yet they thought that if it was a long monolithic document, then their privacy was more protected.
I just wanted to pick up on an earlier part of the question, which was which values, right? And one of I think it was actually 2 of the earlier panels, the question about the connection between privacy and discrimination came up. And there seemed to be some unspoken assumption that by limiting the collection of data, one would address discrimination. And the revelation of data and our ability to deal with discrimination, they have very interesting connections, right? In the context of, you want to apply for a job, and the ADA says we can't ask you for certain kinds of data because you might use it to discriminate, and so we use privacy to limit discrimination. There are other instances, you're an employer, we want you to maintain data about the race of people you interviewed, and that because we actually want to make sure that you're not discriminating, right? And the assumption that privacy solutions are going to address concerns about neutrality, whatever that is, or discrimination, I think are really problematic. That it is not, there is not a one-to-one correlation between privacy and discrimination, and nor is there a one-to-one correlation between the fixes for those 2 sorts of problems, which goes to the question of which values. And I think one of the things that's quite problematic to date in the DNT conversation, for example, is that, as I said, the contestability of privacy, people use the term really sloppily, and they're like, oh, this is a privacy concern, and they're like, people might be discriminated against. Well, yeah, and sometimes privacy plays an instrumental role in limiting discrimination, but that doesn't mean that you should treat those things as the same concern, right? And the DNT conversation is one, not really addressed the discrimination, and I'm using that as in discriminating amongst different groups of people, not just in protected categories, nor has it been attentive to the innovation or kind of competition issues inherent in some of the proposals that are around in the DNT area. And I think that dealing with any one value alone and embedding it in design can be quite problematic if you're not thinking about some of the other implications.
I think the values question is a great observation / question. The way that I look at it from an eBay Inc. perspective is we have many different types of services. And so your values on privacy for PayPal, a financial institution, Luxembourg Bank, may be very different from eBay, the marketplace where you're buying and selling. And so unless we know, at least at a normative level, what your values are across even our own services, it's very difficult for us to then cater our products, design products, the way that we think we may be meeting or providing choices for based on your values. The challenge is that those values that you assign for our services don't necessarily, or you can't necessarily imply, are similar types of values that you might have for other services. And so that's where the regulatory and the legislative areas get very sticky, because, well, you may trust a brand or brands, yet in the same service space you may distrust others, and so your privacy values are going to be very different in that area. So the challenge is as a difficult question, results in a very difficult answer for, I think, most of us at the table.
And one comment I'd like to add is following up on Helen's comment. What I took her to be saying is that in some cases we have to identify subtle value choices that are going on explicitly. So when you were talking about this idea that in the absence of not having sort of a privacy countermeasure, the implicit value choice is that the data gatherers get to gather data. That's the status quo, but the absence of doing anything about it is making an implicit value choice favoring data gathering over not. So just the very act of recognizing these implicit subtle value choices kind of advances the conversation. Yes. All right.
My question is in regards a little bit to the last conversation and trying to get this panel's opinion on it. Privacy by design is about the technology of how you manage privacy, and the last panel was somewhat split on whether the regulation or management of policy should be technical or legal. And I was kind of curious as to this group's view of that, given that the digital world is different than the physical world, and if there's no mechanism for somehow identifying a potential problem, how do you manage that?
I'd say it has to be the legal component, not the technical component. I think we have robust competition on the technical component. Now that may be limited to the services industries within the internet. It's certainly, there's robust competition in the security aspects. If you look at all of the different companies vying for security, whether it's they want eBay's business to help it be more secure, or whether they're offering security services to consumers. If you look at search, you look at browsers, we are seeing robust competition on the technology side. Who can offer what types of privacy protections for consumers? What sells, what doesn't sell? A number of things fail because they misjudge the values or the level of importance of the privacy values of the end user or consumer. Because I feel that there's that robust competition, legislating technical requirements would stifle that robust competition. So that's why I would lean more on the side of regulatory framework and legislative guidelines on the legal side of things.
So I'd just like to point out the problem is that we actually are legislating technical requirements. So as someone who comes from the requirements engineering field, we very strongly believe that you bring all of the stakeholders in the room. So it's not going to be law and it's not going to be technology. It has to be both together. And so until we start bringing all of these people in the room to understand, the lawyers need to understand what our concerns are as engineers so that we can satisfy what they want. And we need to understand what their concerns are. And so one of my examples was I was consulting with a lawyer who was writing the privacy policy for a company. And we had violent disagreement on what should be in the privacy policy. And I said, no, you can't say that because that's not what the software does. And then she'd explain why they can't say what I wanted to say because of liability issues. And then I really started realizing, okay, I'm really understanding this a lot more. And the result was a really good privacy policy that assuaged all of her concerns about liability, but was also very true to the software that underlied it. And I don't see that process taking place.
I reinforce that and say a couple things about it. The first one is there needs to be a lot more education of policymakers and lawyers as to what is the art of the technologically possible and not possible. I think sometimes our regulations are weaker than they could be if lawmakers knew what technology could do, and I think a lot of times they're more rigorous and specific than will survive until the ink's dry on the law. So first thing is I think there needs to be a lot more interaction, and unfortunately probably the worst place in the world to do that is the United States Congress, but that's what we're stuck with. The second thing is, I really think to try to square the circle between what Scott said and what Annie said, what matters a lot is at what level of specificity the regulators try to write law. It cannot be very specific because it just won't survive. But for example, in the information security world where I practice, lots of standards say you have to have reasonable technical, administrative, procedural, and physical controls. And as much as compliance officers and engineers hate the word reasonable, lawyers, can work with compliance people to get specific definitions of that in specific contexts, number one. And number two, it then allows the courts to go out and put flesh on those bones over time. The third thing I'd say, which is definitely going to drive compliance people crazy, and it does the people I talk to and my clients, is once you identify the laws and regulations you need to comply with, I would still say compliance is both the floor, not the ceiling of what you should be doing on privacy, but it's also slightly orthogonal to privacy. Because, like, for example, you know, go try to tell a police officer or try to tell an engineer, go act proportionally, or go be accountable, or go make sure there's user choice and control. But those principles, even though you can't directly implement them, really are helpful, I think, in terms of understanding fuzzy and unclear compliance rules. So if you know that the law requires proportionality, but the law doesn't really say what that means, in your technological context, maybe it means, you know, in a government context, if I'm an officer for the CIA and I'm supposed to be searching U.S. person information, which I have some entitlement to, but not as much as the FBI, the data that gets returned in response to my first search might not include any identifying information about those people. That's proportional to my mission, but that's also something that can be built directly into technology.
No, I was just, first of all, I think there's there's an ambiguity in the question, because one of the questions that it could mean, I have a certain policy and I want to achieve. Is the best way to achieve it through law or through technology? And the other one is to talk about whether law should regulate technology design. And did you mean the first or the second?
More specifically, if you don't have certain technological capabilities,
yes,
how the heck can you enforce any regulation or law or provide warning that maybe something has gone awry?
Okay, then it's neither of the above. But in terms of, okay, so then I'm just going to, I think that on the panel we were answering a little bit of both of those questions. I think that those of us who've been involved in philosophy of technology and so on, we understand that, first of all, there's so many details that you can't possibly manage everything with just one thing. And there's this very delicate kind of interaction among all these different things. So one of the papers that my class reads is about cockpit design. Now you could say by law that we don't have gender discrimination. Everybody, you know, men and women have an equal shot at being fighter pilots. But it turns out that the design of the cockpit doesn't fit women's bodies very well. So you can go all out in the legal side to try and get equality, but the design is not complying. So when you set out to have certain policy ends, the technology also needs to work in lockstep. But the problem with just trying to achieve the end technologically is that the technological affordance is not necessarily always in line with the policy and value ends. So I think, I mean, you know, this is a kind of boring answer. You need both.
And figuring out where you want to position the majority of the work has really important implications, because technical systems can be hard, right? Software less so, but some technical systems can be much harder than policy, which you can violate and potentially get caught. Technical systems can be quite hard to violate, right? They're automatically enforcing in some instances. And so the choice may be in part influenced by how committed you are to the value, how universal you think it is, how often you think there might be exception cases, how do you handle exception, right? And part of the reason that the law is so damn ambiguous is that we believe there's lots of exceptions. We want to save lots of things for courts to fight over, right?
All right, well, please join me in thanking our excellent panel here. At this point, you all have a well-deserved break. Please come back promptly at 3:30 for our next panel. Thank you.
I'm not leaving tonight. My best friend from DC lives here, so I'm going to
No, I'm not leaving tonight. I'm leaving tomorrow.
Me too. What time should I fly?
Georgia treat you?
Are you flying west or flying back east? East. I thought you might get you got away after maybe we're going to see your sister. What's this? Oh, God, it's two. Yeah. When does your semester start?
Enjoyed speaking with you. Loved your comments.
Oh, okay. But I wanted to
Thank you, congratulations.
but it's a great place to be.
Yeah, my brother's at Georgia State.
Do you ever get to sort of
My name is Paul O, and I usually don't sound like this. I am living in DC for the year. I came out to Boulder for the week, but I left my voice back there. And yet, I taught 12 hours of lecture this week, a new course that Dean Weitzner described at the start of the day called The Technology of Privacy. And I subjected my students to this all week. You should find one of them at the reception and just have them make fun of me because every day was worse than the previous. And here we are now, and it's just about to fail entirely. Let's see if I can get through the last couple of things. I always measure a conference's success in a purely selfish metric, which is what have I learned? And I've learned a lot today, and I really do thank you. It's been a long day already, but it's been a really invigorating, interesting day. And there have been so many great terms and concepts and theories flying around in this really interesting world of privacy. Here's a term you've never heard before. It's big data. It's entirely new. I'm sure you've never ever done a CLE about it or gone to another panel about it. And I'll be honest, I was a little reluctant to throw another hat into the pile of people who were talking about this, frankly, because despite all the ink that has been spilled and all the voice boxes that have been harmed, we still don't really know what it is. But we have a great panel of speakers here who are going to speak just for a short time, so I'm going to get out of your way really quickly to talk about this. Like my predecessors, I'm going to dispense with the lengthy introductions. I do want to point out and thank Omer Tenay in particular, who's our paper presenter. He's come to us from Tel Aviv, by far the farthest traveler ever for the Privacy Conference. And it's what time is it for you? It's probably past midnight?
Yeah,
it's past
1 a.m.
It's past midnight for Omer, so I wanted to give him special recognition, and then I wanted to thank Simon and Ryan and Frank, who each come from a different part of the whole entrepreneurship and company and industry ecosystem, and are going to give us lots of different varying viewpoints on big data. But without further ado, let me hand it over to Omer.
Thanks, Paul, and thanks for having me here. I think Paul brought me here in order for this to qualify as an international conference. So, I've already done my thing just being here. I'm going to talk about a paper which I'm writing with my colleague Jules Polonetsky, who runs the Future of Privacy Forum, which is a Washington, DC-based think tank, of which Peter Swire, who's the next speaker, and myself are senior fellows. And actually, Yanni Lagos, is he still here? He's also a fellow. There's Yanni, also a fellow at the forum, so I think we might be we are a small think tank, but we might have the largest group of people here, except for the law school. So the subject is big data, and as Paul said, it's it's a buzzword, and what does it mean exactly? And there are many definitions. People talk about the 3 V's: volume, velocity, and variety. We generally think about big data as the enhanced ability to collect, store, and analyze previously unimaginable quantities of data and tremendous speed and with negligible costs. So the cloud computing model builds into it, and more CPUs per transistor, Moore's law, everything sort of coalesces and comes together for this. Now, big data has very big benefits. And Jules and I talked about this and discussed it in previous articles, and I'm not gonna, emphasize that in this talk, but just as one example, we bring the story of Dr. Russ Altman, who's a professor at the medical school at Stanford, who discovered through analysis of search logs, so Bing search engine queries, a harmful drug interaction between 2 major selling drugs, Paxil and Pravachol. Each of them is used by about 15 million Americans, and about 1 million Americans use both in combination, and together they cause diabetes. And there are very simple ways to replace them. They each come from big families of drugs, the SSRIs and the statins. You can take another one. And they discovered this, among other methods, by analyzing search engine queries. So basically, people who were looking for side effects that someone would get if they had undiagnosed diabetes, and also searched for both drug names in combination, and were much more likely than just searching for one drug or the other with these side effects. It's an anecdotal example, and I think the point is that we tend to focus, and we have focused today here, about behavioral targeting and the marketing framework. And in a way, this focus is misguided. It's similar in a way to the European data protection framework, which today is being reformed. And you get the sense when you read the document, which is a very long document, 130 pages, like font 6, that's the law that is proposed now. You get the sense that it was drafted just to address two companies, which are, based in Mountain View and Palo Alto. So I think we should sort of steer clear of trying to focus the entire privacy debate on just behavioral targeting, because some of these benefits might also be compromised in the meanwhile. At the same time, of course, big data analysis has momentous consequence for civil rights. And in fact, one commentator said big data is our generation's civil rights issue and we don't know it. And it brings up question not only of privacy, but also of equality, fairness, integrity of the political process, freedom of speech, and other issues like that. And sometimes they are tied together or linked with privacy. And I think Deidre touched on this in the last panel about sort of the blurring line between fairness considerations, discrimination, and privacy. And of course, it also brings up other philosophical questions about human-machine interaction and artificial intelligence. And I claim ignorance about these topics. There's a very good book that was released this year, I think, right? Last year, Legal Theory for Autonomous Artificial Agents, which deals with the legal analysis of these issues. But that's not my subject. What I want to focus about, and what we write about in the article, are some of the fairness and equality considerations that come up in the context of privacy and analysis of big data or big data sets. And I want to start with this example. So I don't know how many of you know this story, but Bettina Wolf is the wife of the former president of Germany. So, everybody knows her in Germany and Europe. And when you Google her name, what you get in the Google autocomplete function is a prostitute or escort services. Things like that, and I don't want to be blunt, but that's what you get when you Google her name. And you get this. Just think if something like this would happen to you, and it doesn't have to be this bad. It can be anything, like omertane, conflict of interests, or some autocomplete like this, and you get the sense of what it's like to be judged by an algorithm. In this case, the Google algorithm, which we all, worship and adore and use every day many times. But what is the logic behind this judgment that, she got? So some of us actually know the logic, or we know approximately what the logic is. We know it's recursive. It's like the wisdom of the crowds. Many people were searching for this, right? So that's why Google autocompletes it. But still, is it true? Is it accurate? Can she contest it? And if she does, who would you believe? Well, she does. She sued Google for defamation, but who do you believe? Do you believe the Google algorithm, the Tin Man in this example, or do you believe her? And we tend to think of the algorithm, of the machine, as being neutral. But data analysis is an interpretative process, and any interpretative process is affected by the identity and the perspective of the researcher. And that informs the results. So we shouldn't think of data analysis as wholly neutral, even though it might be affected by a machine. And needless to say, it's not immune to error, to inaccuracy, or to bias. In fact, many times when you look at the advertisements that are targeted at you, you think, what were they thinking? So you're on Facebook, you look at the Facebook ads, and you think, God, these guys, they know so much about me. How can they be sending me these ads? They're just irrelevant. So inaccuracy is not, inconceivable. And the end result is that individuals can feel disenfranchised or stigmatized. And this is an article from the New York Times last year about the algorithm not liking my essay. Our article focuses mainly on discrimination, and as you heard today in some of the previous panels, big data analysis allows for granular distinctions to be made between individuals, between individual characteristics, preferences, and behaviors. And this distinction facilitates discrimination, and I mean discrimination in a neutral sense. Ethically neutral sense, just treating people differently based on different characteristics. It can be a good thing, right? So you treat a child different than you treat an adult. That's a good thing. Or it can be a bad thing when you treat people differently based on their race or sexual orientation. Now, we make distinctions all the time, even without big data analysis, even without a computer or a machine. The machine facilitates these distinctions and enables distinctions to be made on a massive scale. And sometimes it can unearth or reveal some hidden patterns that a human being wouldn't be able to make out from a big pool of data. But at the end of the day, machine-based discrimination isn't any better or worse than human-based discrimination. The machine is just a tool. It's neither ethical nor unethical. And in this respect, some of the legal thinking, for example, in Europe, is that you should mandate human intervention in the process. Don't let people be judged only by a machine. But the point is that requiring human intervention might not help, because the humans might be more discriminatory or biased than the machines. Again, the machine is, stupid in a way. And so the point is that we shouldn't expect the machines to make moral judgments that we have yet to make. And I think I'll give you one example, the Target story. Do you all know this story? It was on the New York Times Magazine. So Target compiles a pregnancy score for its shoppers. So based on their shopping habits, it can detect which shoppers are pregnant and be very precise about it. Okay. To the extent of knowing if the woman is like 18 or 19 weeks pregnant. It's not illegal, right? The law doesn't prohibit profiling people based on whether, well, maybe for employment purposes, but certainly not for shopping, right? Is it a good thing or is it a bad thing? Price discrimination, which we talked about in some of the previous panels, and this is Ashkan Soltani's research with his colleagues at the Wall Street Journal that he discussed earlier. Is price discrimination, should it be commended or is it bad? The machine enables us to discriminate based on price. But whether it's an ethical behavior or not is not something that we can attribute to big data itself. Technology, in a way, is a red herring here. And, in a way, I think that it's not even clear that we would want the machine to be able to distinguish between ethical and unethical behavior. That might be creepier than the stupid machine just making distinctions. But without resolving these moral dilemmas, we can't really frame the privacy regulation or law to address these issues because, again, an example that we talked about a lot today, do not track, just shows the failure of trying to, nail down the specifics of regulation or technology without deciding first, without resolving the big policy questions. What is tracking? Is it a good thing? Is it a bad thing? It's the business model for the internet. That's why we get everything for free. First, we need to resolve that, and then we can sort of regulate the technology. So we discuss in the paper some strategies for solution, but I don't want to take more time, so I'll stop with that and maybe in the Q&A. Great. Thank you.
Thank you. So per the tradition of our conferences like this, I'm going to give each of the discussants exactly 7 minutes, and please take less if you want. There are lots of threats I can wield at you. How about this one? I'm going to start singing if you go over the time. That's a dodgy proposition generally. It's even worse today. So we'll start with you, Simon.
All right. You make a good distinction, obviously, and the problem I always seen with the tracking is, and I run two browsers, one wide open and one heavily privacy controlled. Lately I've been running the one that's wide open just to see what I get. And my concern has been, the ads are so bad. The tracking's not really good. For all the data they have on me, they're giving me the same ad I saw last week from the website I was at the other day, and it's really not a very good experience. And then that follows up if you look what happened with the FTC and their concerns on the children's applications. One of the things I brought up was that one of the ads brought up an ad for singles, for kids. And that's horrible, but think if you're the company, that singles company, I'd be really mad. What are you serving that up to a kid for? That's, first of all, look bad, and none of that, they're never going to go. You're wasting my money. And there's a marketplace way to fix that. And so the machine, I think, can get better with more data. And that's an odd thing for me to say as I'm running my privacy side, but I can see where the machine can get better. Now, the concern I do have is on the other flip side of the kind of the Orwell-Kafka thing, Kafka to Orwell, is that when government does it, though, right? Government doesn't really have the same incentive to fix the machine. So if they accidentally arrest somebody or conduct an investigation, which can be almost as bad, and start seizing documents and dragging you through the mill because of your searches, there's not the same punishment mechanism that goes on there, right? The government, if they wrongly incarcerate you, maybe you can get some money when you finally prove your innocence at the end of 10 years or something, as happened with some of the cases. But that doesn't have that safe self-enforcing mechanism that the marketplace does. And so I share your concerns around the machine, and also you're probably right, you don't want to have the human intervention piece because, first of all, it can't work fast enough, but you do want it at the end, and I think you do get it at the end with the marketplace correction.
Wow, that was fantastic. Thank you.
Singing.
Yeah, no singing at all. Ryan.
Great. Well, I'll try to keep it reasonably short as well. So, my perspective on big data is as both a former technologist and software engineer. My early life, I worked started a company that sort of led to some of the big data stuff we're talking about right now. I can go into that in a second, but that big data is a buzzword. It's very much a rapidly changing technology that's still in its infancy. And whenever I hear talk of, should we regulate it, should we do this, all I can think is, what an insane sort of drag on innovation in general, from my perspective as a venture capitalist investing in startup companies, that could create. Because first of all, given it's a fast-moving area in the technology business, any attempt to regulate it is by definition sort of looking in the rearview mirror. Things are going to evolve far faster than the regulatory framework can keep up, and that really a marketplace solution is
is ultimately what we need to look for. I read a quip the other day about big data, that made me laugh. But big data is like teenagers and sex, right? Everyone's talking about it, but very few people are actually doing it or are any good at it, right? And so it does present this sort of specter of used wrongly in the hands of Big Brother type outcomes. But also, to touch on the advertising piece, we've got a portfolio with a number of advertising technology companies, that sort of rely on big data type technologies. The idea of putting a human in the loop, at least at sort of a very basic level, in some cases, is impossible, right? There's a thing in ad tech, it's called real-time bidding, right? Which is how most ads are served now on the internet. And if you're a company that offers this service or wants to participate in that ecosystem, you have to be able to respond to a request for an ad in 120 milliseconds, right? And that's that's sort of the ante for being part of a real-time bidding marketplace. So clearly, at that sort of functional layer way down low, you can't have a sort of human in the loop. But obviously, ultimately, it's the humans who design the algorithms and the decision-making processes, and that's where I think it needs to come back to, which is we can't blame the machines for the things we implement, and although in some cases, again, given where big data is going and areas around machine learning, there were some great articles in the New York Times and the Atlantic about this sort of deep learning stuff that Google's done based on neural networks, where they were able to train. They took a sort of neural network of unprecedented size, a billion neurons in the network, 16,000 CPUs, and they trained it with using something like 10 billion images from YouTube. And what they wanted to see was, can we make a neural network that can identify a face in an image without any human intervention? Right, so it was really, we're going to show it these 10 billion images as its training set, and then we're just going to test it along the way against sort of these known set of face images to see how well it does. Well, this thing performed 70% better than anything previously had. And, that's where you get into this murky domain where there are now some technologies and some sort of means of machine learning that are so big and so vast that where we don't really necessarily understand the hows and whys of how these neural nets and things are making decisions, where I do think it gets into an interesting gray area where you could build, a giant data model that's sort of beyond the ability of any one person or individual to comprehend how it's going about its decision processes. And to me, that's kind of a fascinating area where the sort of the assertion that it's the humans in control break down a little bit. I think that's kind of a fascinating area for further discussion as well. But in general, again, coming from the startup and technology side of things, it's very much I think something where the industry needs to lead with solutions. We actually have an investment in a portfolio company that we think is sort of part of that trend. It's a company called Singly. And basically what it is it's an integration point for any other web developer who wants to access information and services about an end user. Sort of it's a single point of control. And what that does is it both benefits the app developers because they don't have to spend all their time writing all these sort of one-to-one connections with third-party services to ingest the data and do interesting things with it. At the same time, and so it saves them sort of, makes them able to bring products to market more quickly, lower cost of integration, et cetera. But it also puts the end user in control of their data, so they can go in and basically, register and validate all the services and all of their accounts, and then be able to see and proactively, allow these other apps access to it and understand who's accessing what. And I do think that over time, the solution needs to be both sort of consumer driven, at least with privacy as it relates to advertising and marketing.
VRM.
And VRM, meaning expand the algorithm for me.
Vendor rights management, dog cereals, intention economy.
Exactly.
The user in the center in control, and like fourth parties, he calls it, having access to the data.
Yes, exactly. And I do think that that's sort of the path in my mind where a lot of this stuff needs to go, but we are still at sort of inning one with respect to
what big data means, what its implications are, and even just the development of the fundamental technologies underneath them. And my final thing I'll say is just to go back to a definition of big data. I mean, big data is what happens when you're writing software and systems and information that no longer fit on a single physical server. I mean, that's effectively what it is, right? And it goes, where you're sort of doing data center scale computation. And really a lot of that work was originally pioneered, a lot of stuff in academia, but the real sort of practical applications started happening with early search engines, Excite, Google, Yahoo, et cetera, and the development of systems to cope with just the massive amount of data that was coming in from user logs, user activity, and the simple fact, trying to index every page on the internet is a pretty insane ask, and you needed fundamentally new technologies to do that, and that led to development of things like Google File System, Bigtable, which led to Hadoop, which is sort of one of the fundamental open source technologies, and it's so we can sort of blame the birth of the internet and search engines for sort of enabling folks to be able to do this kind of thing.
Great. You guys in the back, can you hear? Okay,
I'm
so
sorry.
let's all lean in a little bit.
All right, I will speak.
Ironically, you can probably hear me, and you don't want to, so next you, go ahead, Frank.
Sure. Well, first of all, I think there should be a new rule. Whenever anybody says big data, there should be reverb happening.
Well, we can take it.
Sounds of thunder. It's interesting. This is my first trip to Silicon Flatiron, so I thank you and Paul and Scott and Phil for the invite. And I'm assuming it's because folks in town knew that we were coming here for this conference, that the Boulder Weekly ran, this week, their latest edition. This is your brain on the internet. It's an angry bird kind of smashing into a brain. And the premise of the article is that the internet is causing or destroying civil discourse, and I would argue that actually this conference proves that the internet is actually promoting civil discourse because we're talking about these great issues. And I kind of want to ground us a little bit in terms of what's happening today in terms of big data, because it's not, Omer, you showed some examples, but there's some other things going on today that I think highlight really the problem of privacy policy keeping up with the pace of the push of technology, and in this case, big data. The first example I want to bring out is in the healthcare space. I don't know if folks have followed that. For years, HIPAA was the law there, and that was fine. But as we started to move towards electronic healthcare records, both in terms of the Health Reform Act and then in the stimulus bill, providing more funding for more healthcare providers to use the cloud to get electronic records, all of a sudden we have a somewhat explosion, a slow growth, but still more people using this than not, and people are, healthcare providers, small medical practices are going to vendors saying, help me get on the cloud, help me do email and do all these sorts of things. And what HHS is finding now is that sometimes healthcare providers doing even that aren't complying with the existing HIPAA laws. They're not signing business associate agreements. There's a recent case of a Phoenix called Phoenix Cardiac Care, a small physicians group, signed on to a vendor to help them keep their scheduling and whatnot, and a patient happened to Google themselves and found their schedule for their surgery up online for the world to see, and that was a problem for HHS and the patients there. And so, I raise that as an example of, the notion of the cloud kind of allowing for big data to happen for all, potentially very good beneficial reasons. This is going on today, and we need to take some care and some caution. Advocacy group called Patients' Privacy Rights recently wrote a letter to HHS saying, hey, maybe you ought to be providing some guidance around security measures, compliance with HIPAA, making sure there are business associate agreements to healthcare providers, small ones, big ones, just so that folks know at least the baseline, at least to have the baseline. The other area where there's more use of the cloud and potentially big data for all the right reasons is university settings and in other educational space, K through 12. Great, more efficient, again, all the right reasons. But, there was a recent survey that came out saying that, parents really don't have an understanding of what goes on with their children's privacy in the school setting. And so that begs the question, should there be more transparency then as we go to big data in the cloud, especially for this potentially vulnerable population? You could see the scenario where, those records get into the wrong hands or up in the cloud and it's not protected, that there's some, potentially bad things that can happen, or, things that should go away are still kept, and what happens further down the road. And so again, that there's FERPA, which is the law that protects student records from being used, but, I think somebody posed the question, if you've got a child, in elementary school or high school or preschool, ask their, and the school is using cloud services, ask them, do they have, not necessarily a chief privacy officer, but anybody minding about the privacy and security of the kids' data? And the answer posited was probably not. So again, there are things going on right now that highlight the need for kind of more immediate action. The paper was good, and I know we'll talk about the solutions later about, painting the big picture, but I think we constantly run into this problem. I remember back in the Clinton administration when the internet was kind of new and Ira Magaziner made his proclamation, kind of hands off the internet, let it happen, and now it's happened, and now we're still talking about privacy and how to protect privacy years later, and nothing was kind of done at that time because everybody got into the hands-off mode. Are we going to do the same for kind of big data? So are existing laws enough? If so, are there, is there compliance? If they're not sufficient, do new laws need to be passed, or do they need to be revised? And again, this is just the beginning, and the paper calls out, potential future uses of big data. Pew did some research surveying the experts, and kind of called out, like the paper does, kind of this yin and yang of big data, which I think Dana Boyd, Microsoft researcher, may have summed up best by simply saying that with big data we'll get the good, the bad, and the ugly. And who knows how it'll all come out. And I think the challenge is, and what the paper gets to, is how to promote and encourage the good, mitigate the bad, and eliminate the ugly. And then I'll just leave you with this. I don't know if it was the altitude or what, but I had trouble sleeping last night. And so I kind of had this dream, and I kind of went from the Minority Report, because I was thinking about the panel, and Tom Cruise running down the street, and the advertisements coming up, saying, oh, we know you're interested in a car, and doing all this stuff. And then I kind of merged into the Matrix, where it's like, forget the person even running, we're just going to keep you in a pod and kind of filter stuff into you because we kind of know what you want, and we can do that. And then that morphed into the Terminator, where it's like, oh, forget the people, it's the rise of the machines. And so I'll just leave you with that. But then when I woke to the at the time beautiful sunshine that has since gone away, and I thought about the title of this paper, I remembered that even the Tin Man got a heart at the end.
Oh, that's good. Wow.
Instead of Paul singing, we got Frank reading.
Poetry kind of. So allow me, and those of you who know me know that I have some opinions about this topic. Allow me to give my 2 cents about the definition, and then I'm going to have a follow-up question for all of you. So my thoughts on the definition are, I think throughout the history of technology and policy, particularly with the internet, there are terms that are somewhat well-defined in the technology space that then get hijacked and misused in the law and policy space. And I don't think that's a bad thing. I think that's what we do with language, right? And it's what we do with language that's particularly evocative. And I think, honestly, big data doesn't seem to me to even be that widespread a definition anyway. So it seems to me that when lawyers use, and tech policy people use big data, I've said this joke before, so sorry, to channel Linda Richman on Saturday Night Live, big data, neither big nor data, discuss. I think what we're often talking about just analytics that are really powerful. And the Target story was this example that kind of brought it all home. And so to me, big data could start to be like big oil, right? It could start to have this kind of negative connotation that, I'm sure would make some purists really unhappy, and others, would use it as a tool. I'm not saying any of this is going to happen. I'm just saying I think it's a jump ball. I think we're still fighting over what it means. Okay, so let me, this is a conference on privacy. You said a lot of really interesting things on discrimination, And as Deirdre said, the relationship is kind of complex. Let me focus on privacy. This wasn't in my set of questions I said I'd ask, so I'll make it available to any of you, and you can volunteer to answer it. So Omer has this example on his benefits slide, right, of learning this new interaction between two drugs, in part through a Google search. And I'm guessing, was it Google?
Bing.
Bing, okay, through a Bing search. And so I'm guessing Microsoft in its terms of service said, we reserve the right to share your information with third parties for lots of purposes, and one of them was broad enough to include health research, I suppose, right? So the question is, oh, right, exactly. I forgot who was on the panel.
Good question.
So the question is this truly the best example of pure benefit, very few costs, or enormous benefit, so who cares what the costs are? Because I could tell a story that says those people who entered those search queries did not realize that this is what they were buying. So what do you guys think? I mean, does this seem like Omer's right? I should stop asking this question. This is great benefit, or is it a more complicated story?
I think, there may be a temporal aspect here, because I think if you ask users ex ante, before the fact, are you willing to sort of have your search queries or clickstream analyzed by researchers for health purposes or fraud detection in the payment card industry, most users, my intuition is, would say no. Right. You have no business looking at it, But when you see these results, when the story is told, it's like a no-brainer. Of course you should do it, So, I mean, it's so compelling. So I think it's difficult to answer the question, and in a way it depends, the answer depends on the legal framework. So if it's a consent model where you have to have consent at the outset, it probably won't go through. But wait a minute, maybe it shouldn't be a consent model because of this.
Go ahead.
Hang on, I'm not necessarily asking this in terms of a legal question. I'm asking this in terms of an ethical question, which saves Frank from telling us whether or not this was like, by doing.
Well, I know the Bing team, and I'm sure it did not violate our.
Yes,
yeah.
I'm sure that's
well, right, and that's what I was going to say is, I can tell you, not even being a Microsoft employee, that there is no way that data wasn't completely sanitized before it was handed over to these researchers, right? It had some unique user ID that was totally unindexable back to any actual human who was known.
But that's
right?
what Netflix thought when they
made
their data available.
No, that's what AOL thought.
AOL also,
These are search queries, right?
Right. So
and that's I mean, Arvind will re-identify anything.
Right. So that is true. Again, taken in the sort of, if somebody has sort of a nefarious goal or a profit-driven goal, but particularly in a case of this sort of unquestionable good kind of outcome, if it's a health researcher, the beauty of a search engine is that it's the sort of world zeitgeist funneled into this one little search box, right? It goes back to your autocomplete thing and the German example, right, which is. That was not the machine making a judgment. It wasn't even the algorithm designer making a judgment. I mean, it was really, we autocomplete based on which searches are statistically most common across the hundreds of millions of users who are doing this. So, blame humanity as a whole for associating, the chancellor's wife with prostitution, right? I mean, but again, I think that certainly a tenet within the industry is that all sort of data is if it's ever going to be shared or used for research purposes or whatever, is sort of cleansed of unique identifiers. Now, granted, I'm not arguing the fact that with the right technology you can sew some of this data back together. But
no, so I think just to challenge two of your assumptions. First of all, as I said, the computer scientists will show you that they can re-identify. And second of all, the purposes being sort of the ultimate good here, that's, I think, as Paul said, it's a very fragile concept because you can use the health research to discriminate, and insurance premiums will go up. So it can have like harmful effects for individuals regardless of the sort of the social good.
I agree, and I mean that's a whole other issue, particularly as it pertains to healthcare and whatnot, right? Which is maybe big data is a good thing in some cases there. Maybe I'd like much lower premiums and not paying for the smokers or the people who have given themselves diabetes through their diet, right? I mean, and I know I'm saying that to be totally provocative because
which goes back to the price discrimination question. Is it good or bad? I mean, someone pays less, the other pays more. Is it socially regressive or progressive?
Depends how it's enacted and what it is, and it's been going on pre-internet as well. So it's just internet always brings scale, right? And now you can do it bigger and perhaps more granular. But at the end of the day, the question is like, is big data good or bad? It's like saying, well, the automobile is good or bad. Well, there's some good things, there's some bad things, and I don't know how you weigh them in the end. Even at the beginning when we're doing
So Frank, now describe the meeting where you approved this research. that was a very nervous laugh, I will say.
If there's one thing I learned in law school is if you don't know the real answer to the question, say you don't know, and I'll get back to you.
Don't say it, you can't.
Well, first of all, I'm not sure if it was a big inquiry or not. That the person did, but even assume that it was, and assuming that the information was kind of de-identified or anonymized before it was handed over. We've got some great researchers, Cynthia Dwork and others, to kind of parse things out and make sure things stay anonymous. But I think what it raises though is kind of a more fundamental question. And kind of at the crux of the matter, about the future of big data. I mean, this thing could just happen on its own and continue and grow, and everybody will, turn around one day and say, oh my gosh, what do we let loose? Or we can have these sorts of discussions and say, what will the new norms be, or what should the norms be as far as using data for the social good, and do we put in restrictions so that you can't re-identify it and use it for bad things and whatnot? But what should the rules of the road be? And I don't know, as just my own personal preference is, hey, if I know that some data about me, if it will be protected and anonymized and all that, can actually help the public good, I'll probably say yeah and agree to it if I'm kind of knowledgeable about, if I'm provided some, notice that is something that could be used. If it's used for a commercial purpose, I may want to have the choice to say, no, for common good, I'm all for that. If it's going to, save somebody or help humanity or give a better traffic pattern so they can rejigger the lights in DC so I'm not, stuck at lights because they're, tracking the users that go through, the cars that go through the lights, and rely on big data to make that all more efficient, great. And so I think we're at kind of a juncture of how do we explain to the general public the benefits, kind of characterizing the risk in an appropriate way, providing the notice and kind of, I know people go back and forth on the FIPS, but kind of, fundamentally, are they kind of one of the paths forward here?
I think just to add to that, I think the FIPS fail miserably here because if we look at some of the FIPS, so consent or individual control, data minimization, which is antithetical to, you shouldn't even collect it. What's Microsoft doing even, retaining these data? You should delete it immediately. So you say, wait a minute, but there's like a huge social benefit, but it runs against the current privacy framework. So this really, presses us to reach some conclusions, policy conclusions.
So then, I'm totally off my script, by the way, gentlemen. So, so then,
aren't you always?
I always am. I live my life off script, yes. So then, the one thing I hear in all of this, though, and you start your paper in a very nice way, describing how basically every one of us in this weird crowdsourced way has become a human researcher, right? Small garage startups, big companies, bloggers, we're all doing human research on data about one another. Facebook, right? That's what that is. And you also say that forget about FIPS and forget about substantive privacy law, there was also a layer of institutional control, right? So up until now, because we learned a lot of bad lessons about a lot of medical research, we've had things like institutional review boards, we've had promulgation of rules from the federal government that said when you are going to start messing with people's lives, we're going to analyze it, and forgive me if I'm butchering the IRB rules, we're also going to take into consideration the benefits and the costs. And so it's not just Microsoft's organizational hierarchy that decides what's good or bad for society. It's some sort of external, neutral arbiter who has internal rules to make sure they're playing by the rules. Is this a big problem? I mean, should we worry about the fact that every one of us now is a social scientist or worse, right? I mean, what do you guys think about this? Should we try and replicate the IRB writ large across society?
Well, first of all, let me say, as far as search goes, we are this big and the other player's this big. So, I just wanted to call that out.
Medium data, right?
And so, but you know, Paul, I think that.
Can you believe Microsoft says that? I mean, it's,
well, but it's, you know, but it's true. It's true, and you know, Google, I think, was one of the first on the scene with their H1N1, you know, flu tracking. That at the time everybody said, kind of, this is a good thing, right? I mean, this could be helpful, and I think the jury might still be out. And Paul, I know you've got some views on kind of whether or not this is, you know, big data beneficial, or are we on the path to ruin here? And I think it will be, you know, putting out more examples of the potential benefits and getting the public engaged in new and different ways. And I don't know if it's through social media or other things that kind of allow them to give some permissions. And I kind of agree with you in part, you know, about the FIPS in their current form might not be, you know, directly useful, but we've got to come up with something. I mean, because as we move into a world where consumers actually, or the public or citizens, want more personalization, they want more personalization, you know, there's a potential for more data to be more useful, and it would be a shame if, you know, going down the road, other drug interactions aren't found because of a reluctance to trust what's going on. If we can't become energy independent or, you know, save cities money because we don't have access to big data because of the trust. You know, so at some point, at least in Microsoft's mind, and one of the reasons we've been big on privacy through the years, on do not track and a bunch of other things, it's because, you know, folks at the highest level of the company get that if we don't have the trust of users, not just for our company, but kind of across the board, then, you know, does the benefits kind of start to scale back once people really realize what's going on, and, you know, a backlash. So how do we get the public up to speed, give them the ability to make, you know, choices, inform them in the right way, and move forward with the benefits from there.
And this, again, there's a marketplace mechanism for this, in the sense that if you de-identify, which isn't anonymization, de-identify means we're really trying hard here, but you know, we realize either by really good tools or maybe just dumb luck, someone put pieces together. But you know, in the event that something does happen like that, has happened in the past, the plaintiff's bar comes out and raises whatever hammer they can, and then that kind of tweaks the industry. You know, maybe that standard for de-identification wasn't good enough. You got to push it up a little more. You should have done this other thing. And so there's a correction element that's built into it. The problem with consent, even on something good, is, you know, organ donors. Right? It's a great thing to do, but a majority of the population, my understanding is, don't check the box to be an organ donor. Right? You don't need it anymore, right? And what a great thing to do, but there's a reluctance to give permission. But change is a hard thing for people to accept, and they're not willing to give permission often. And so with something like this with consent, and trying to have a review board across the whole thing would, I think, be very difficult to implement.
Okay, let's open up for questions. The Weitzner rule is what I call the students must go first rule. Remains in effect, and they know now that I will pull the trigger. Yeah, go ahead, Andrew.
All right, so I guess my question is, with respect to the threat of people de-anonymizing this released anonymized data, for example, when Netflix released that data and people were able to stitch back together and figure out who rented what movies, what is the concrete threat of that actually happening? Or is this really more of a kind of an abstract problem that could possibly be a problem in the future? I guess I'm struggling to see a scenario where we have like a black hat hacker or something going through this anonymized data, putting all this work into stitching it back together, just to find out that Terry Sharp in Detroit, Michigan rented Terminator last week. I mean, what is the actual threat here? And does it outweigh the benefits of big data?
But I think Paul must answer this one, because he sort of wrote the book on this and the database of ruin. You should talk.
I mean, Yes, we took a whole class this week together, but I didn't actually get that question. I appreciate it. I mean, what I would say is you raised the perfect point, which is it's all about the threat model at the end of the day. I mean, earlier in the panel, they were comparing security and privacy. I agree with all those speakers who say they're very different things, but we can learn a lot from security. And one thing is, when you're looking at individual circumstances, you should look at things like the threat model. And you're right, you look at what is the incentive for someone to learn what those movies were, and frankly, crassly, what was the dollar incentive for them to learn what they are? What are the security controls that are in place? How much historical trust do we have in that? How many people can touch the data? And it's why whenever I'm asked the identification questions, and I'm asked them quite a bit, I always say, well, are you talking about health researchers who have this very tightly knit, well-organized, IRB-administered systems of trust that we have a long history with? Or are you talking about commercial vendors and advertisers who don't, right? And who instead have incentives in a recent track history of keeping data only so long until they can find the next person who's going to buy it from them and try and monetize it. And so I, think those probably are near the extremes. And in the case of Netflix, it was a public release to everyone on Earth. So if the probability that someone would try and re-identify was 0.000001, you multiply that by 7 billion, you're not quite at, it's going to happen for sure, but you're at a lot higher number than you would have been had they instead limited that release in certain ways. And I have to be very careful. I think the Netflix Prize was this wonderful, amazing boon for innovation. I think the public release is what really kind of troubled me with what they did.
And the other part of that answer is look at the history of the Video Privacy Protection Act, right? That whole law was put into effect because they were looking into Borg, right? Borg's video rental history, and that's probably one of the strongest protections out there. It was
until a couple of weeks ago.
Until a couple of weeks ago, that's right. Yeah, but still, it's a very strong protection on what movie you rented, because it's not that someone who no one really knows except for a smaller group rented an innocuous movie. Is a prominent person rented something that would raise an eyebrow.
So we have time for one or two more questions. Aleecia?
So I wanted to ask a question responsive to a point that Ryan made, which was, we've heard from a lot of companies they have a hard time knowing what data they collect, to the point that I know one chief privacy officer who ran a contest and had a raffle for people who could identify what cookies the company set, right? The problem is you have acquisitions, you have turnover, you don't even, his problem at the end was, in addition to he had 40 cookies, he still didn't know what the heck they were. He didn't even know if he identified the entire universe of cookies that his company set. So that's a problem as companies age and these systems become more complicated and there's nobody who holds that all in their head as to what's going on. Similarly, we have a lot of complexity in the ecosystem of where data moves, and so we're hearing that there is no one company that's able to say, I have data, I sold it to somebody else, and here's where it went. No one knows. No one is able to answer that question. And so what we heard from Ryan was, we have this great thing happening with these really complicated algorithms, and they're going to be so complicated that no one's going to hold that in their head or understand how this data gets used. So as I'm going down that list, right, we have collection, how data is transferred, and data use. And we may actually have, in cases, no parties able to intervene to have transparency and control on those. So I was looking for reactions from the panel. Is there a place where there's a good intervention? If there isn't, what does that imply, and what do we do?
Small question. Small question, but in the timing of the panel, it's perfect, right? I mean, this is your chance, okay? This has been a panel mostly about problems. You're all going to solve it for us. This is your charge. I'm not going to let one of you take a pass. Solve a piece of what we've done, given kind of the intractable problems we've already talked about and that Alicia's teed up nicely.
I have to solve it.
Yes.
Well, I can propose some solutions or sort of paths to solutions, and I think, first of all, you should probably take care of yourself. So, data minimization, I think, is an individual responsibility, first and foremost. And people shouldn't share data they might be concerned with later if they don't have to, or people can use privacy-enhancing technologies, and I think we heard about some of them today. So I guess pets, that's one class of solutions. Another class is empowering individuals not with a notice and choice model, which didn't go so well, but rather with access to data in a usable format. So there is a sense now that there is like a wall, and behind the wall there is this accumulation of data, which Paul called the database of ruin, and we're sort of locked out of this, and we can't, share the wealth. So I think if we could at least access our own data in a usable format and gain some insights from it, or have some tangible gains from it, and I think this may be what Ryan was talking about. So a user-centric model for data management and then allowing access to certain apps. It would empower us in a different way. And then de-identification, I think, is still, an important strategy. Frank mentioned Cynthia Dwork's work on differential privacy, which is a good response for de-identification, even in the context of public disclosure of data. And certainly without public disclosure, there can be legal and, regulatory responses to limit dissemination. So,
Simon. Well, I heard two problems. One on the cookie side, which I think is fixable. On the data side, a little trickier. So let's address the cookie one first, which is that I hadn't heard that before. In a way, I'm not surprised, but in a way, I'm thinking, really? Because to me, you're buying a company. It's one of their assets. It's the cookies that they have out there, and where they may be, and how we may track them. So I think there should be at some point when you're acquiring a company, what patents do you have? Another piece of property are the cookies that are out there, and so there may be pressure. I would hope there'd be due diligence over time where you go after that and try to realize what you have out in the field. The other side, even with data minimization, I agree that as an individual you try to limit what data's out there, but you really don't have that much control at the end of the day because if people have data about you and you're not sure where it's going. And once it's out there and get replicated. So what do you do with that? I think it's a harder piece to fix. And part of it might be either, again, good old court system, you put together something that's incorrect about me, or, and I'm curious to whether or not Bettina Wolf prevailed. My suspicion she wouldn't, at least not in the U.S.
I think it's still going on.
It's still going on. The other side is then trying to, the best defense against bad speech is more speech, is maybe try to improve the data. But, I think it's going to be a big societal problem. And I suspect as a society, there'll be developing of new norms, new expectations about what's private and not private. Maybe people will learn to do, as they do in small towns sometimes, kind of look away or create a fiction around, we know that's true, we know this about this person, but we're not going to do anything because the implications around that are worse than knowing.
And Ryan, feel free to say there are no problems to solve. I mean, that was a little bit in your earlier.
Well, so first of all, I'd say, as somebody who's developed software in the past, right, the cookie story is no surprise to me, right? I mean, it's because humans write software as well, so they're, it's just sort of, that's a fact of the matter of rapid development, features getting deprecated or forgotten about or whatever. I mean, it's really easy to, and then the other thing to remember is that, cookies in and of themselves, again, sort of a neutral technology. Usually most websites are using them simply to sort of track the session, and it is some anonymized or version because they're using it to dereference the stuff that's sitting on their servers that they consider proprietary, that they don't want to share with the world, so they don't sort of actually load the cookie payload with that. Yes, you got to do data minimization on your own part. You got to take care on your own part. The other thing to remember is that, and we see this all the time with, especially advertising-related technologies, is, for all the data that we have, right, and that companies have that are able to use to sort of better target end users and advertise to them and whatnot, it's still pretty bad and still pretty, it's not. When you realize how dumb all the systems are and how much they are not interconnected, you can breathe a sigh of relief because the idea of some giant nefarious machine in the sky really stitching all this together, we've got a long way to go before that. And so much of the data exhaust that you generate throughout your online life, really serves to confound a lot of these systems, right? There's so much noise in that data, right? It's like, if I go off randomly on some, sort of web rat hole, reading about, capybaras, which are like the world's largest rodents. I'm using this as an example because I did it the other day, right? Which is, like, has nothing to do with me and never will again. But there are, somebody could sort of stitch together, my interest in them, and I might be getting ads as a result of that, right? Which again, it goes back to like the marketers who are spending money on these ads, are just really sad that their money's being wasted, as a
bad
result.
theory of view, as
Yeah,
right. Like
and it does. And so one of the things, as much as I like the idea too, and we have a company that's kind of working on that, I think like the idea of having, and you should have sort of consumer control, and I think that is a technologically solvable problem. I don't know if it's sort of a sort of realistically solvable, but where if you get to the point where you had a place you could log in and understand what all the different applications were that had ever seen data about you and what exact data they had and all stuff, that's at least feasible. It probably needs to be a federated system and not anything that's sort of mandated and one single thing, because what if you really could have a central point of control that really did track every piece of data that was ever generated about you and put it all in one place? I'd be a lot more scared about that existing than the current status quo, where at least you have to be really smart and crafty to de-anonymize my data and stitch the stuff together in a nefarious way.
I think we're all lucky that we don't need to come up with solutions to this, and nor do you anymore, Aleecia, but Peter does, so maybe Peter should give us the solution.
Really quick, so I'll be real fast. First of all, I don't think there's any one thing or any one entity that ought to be burdened with this. So it shouldn't all be on the user, the consumer, to kind of figure this out and sort this out, because consumers simply won't. But it's all good. I think people should be concerned about minimizing the data that they put up and certain other things. But there's also some obligations on the companies that are out there, including my own, and other big players in the marketplace, to do what they can, especially around transparency. There's been lots of talk about use and about accountability. That coupled with something that we've long supported, a comprehensive federal privacy bill that was talked a little bit about earlier, as well as what Julie was saying about the Fair Credit Reporting Act, that we need something like that to provide the protection. So it's not one thing, it's kind of the ecosystem, individuals, companies, the industry, thought leaders like folks at Silicon Flatirons, and other academics need to kind of help sort this out. And then does there need to be kind of a regulatory or legislative overlay to kind of resolve all this?
So please join me in thanking the panel for the wonderful discussion. Do not move a muscle. That was a short panel, and we're going to go immediately into our final piece of the day. It's really my pleasure to introduce Peter Swire. I'm going to sit up here and get to ask the first question. Peter Swire is a professor at Ohio State. He's also a fellow at many, many, many wonderful institutions in D.C. He served on the Clinton administration, the Obama transition, and on the Obama administration, and he dealt with privacy in his portfolio in all three of those. But most noteworthy from today's discussions, Peter has agreed to co-chair the W3C Tracking Protection Working Group. You've all heard that. Peter and I talked about having him here, and I thought it would be a wonderful thing at the end of the day, a rich day, to have Peter give you his thoughts, and also to kind of have this serve as our group hug as Peter begins his new foray into W3C, and for us to give him some advice if he wants it on what he should or should not be doing. So without further ado, Peter Swire.
A group hug could be much welcome in the W3C process, as Aleecia and others have seen. You can get the personal attacks on almost a daily basis, so I think maybe we'll get to 5 o'clock without that today. I hope so. Thanks, Paul and Silicon Flatirons. Thanks to Aleecia and Danny for, Aleecia was chairing this for 18 months and deserves incredible recognition for the energy, time, and wisdom she brought to it. Danny worked at W3C earlier in his career before he came into the administration, and so we have some real expertise, on a global level here in the room, listening to whatever it is I'm going to try to say about this. I was named to this position on Do Not Track in the end of November. I hadn't planned on it. My classes were ending. They asked, do you want to do it? I said, okay. And the thing leaked about a week later, so that's how I got announced. What I'm going to do is do a very brief history of how we got to Do Not Track in about 3 minutes, and then I'll give you 3 views on how to think about the process today. And the three views will pick up on things we've talked about in the course of the day. So cookies in the late 90s. I was working in the government. One story about cookies is the White House website had a no cookies policy. And one day we woke up and it turned out that the drug czar's office was using DoubleClick and was cookieing the heck out of people who visited their website so that maybe we could figure out which 15-year-olds were looking up marijuana on the internet, and then somehow, because there were ads from the White House drug czar to drug-related sites. And this was maybe a surveillance tool for the FBI, at least the way the press described it. That broke around 8:30 in the morning. And at 2 o'clock that afternoon, the United States government's federal cookie policy was promulgated by the Office of Management and Budget. It was all the way to a final policy in 5 hours. That was sort of partly because of the hearings that were coming up the next week. And that's not been characteristic of the speed things have worked in this space since on some occasions. In that period around cookies, which is the first-party websites, normal, you go to a website, and then somebody has a cookie there, and it was DoubleClick was the most famous. That was the early web, and the Network Advertising Initiative, a self-regulatory group, agreed to a deal in 2001. And they were going to have good rules for those cookies, and you could opt out of it. And that was I think, an important step. And then the internet bubble crashed in that period, and online behavioral advertising went to almost zero for a period in the early 2000s. And so you didn't hear anything about this. But then things started to come back up, 2007, 2008, and the rest. The FTC started to have hearings. And in April 2008, Annie Anton and I, Annie you've heard from today, submitted testimony to the FTC about the opt-out cookie process for tracking. And we were pointing out that the cookies weren't working just perfectly, that if you set your opt-out cookie on, if you went and were being tracked on Monday, you set your cookie on Tuesday saying, don't track me anymore, please, then you might clear your cache the next day. And when you cleared the cache, you were clearing out your opt-out cookie. And so the day after that, you were being tracked again. And so you were being extra careful. You say, I opt out, and I'm going to clear out all my cookies, and you were being tracked again. And there was a feeling that that wasn't a great user interface experience, right? I mean, that's just not quite perfect. And there's been this commotion, this effort. Online advertising revenues have gone way up. The number of players has gone way up. And it was not only hard to get on the opt-out list, but it was hard to find out where to go to the opt-out list. And so the FTC and others helped to put pressure on the industry, the advertising industry, the Digital Advertising Alliance, to make it easier to find. And so now when you surf on this ads, there's this icon that's there, and they've served over 1 trillion impressions. That's really fun. They're really happy when they get to say, we've served over 1 trillion ads with our icon on it. Have any of you ever done anything in trillions? I mean, that's a lot, right? I mean, that's, but on the other hand, what does this ad icon really mean? It tells you what you can do and how you can opt out. They also have done something else. So now they have a plugin. If you go to their opt-out site, you can, in your browser, find a way to harden the cookies so they don't get deleted the next time. So we actually have a technical tool that will let you opt out on a page that you can get to from these icons. Those are pretty good answers compared to not having those answers. However, people don't really know what that icon is. And, has anybody here put that plugin in to harden their cookies, their opt-out cookies? This is our technology and privacy panel. Peter Eckersley has done it probably professionally to see if it works. Is that right or no? Sort of? Okay. Because Peter's on the front line of looking at the claims from people who maybe haven't done it perfectly on occasion. But beyond that, so we haven't scaled that consumer choice mechanism. And so when you think about this cookie thing or whatever, maybe it would be good to have a one-stop, the consumer clicks once, persistent, it doesn't get wiped out when you clear your cache, and widely recognized around the web way for you to control the tracking. Wouldn't that be good, right? Then real people could do it once, and it would stick, and people would recognize it, and we would have do not track. And so for just this moment, feel optimistic and happy. Okay? Because that's sort of the vision, right? That's something we could feel we've accomplished if we have this ability to be persistent and one-stop, widely recognized, and consumers can really do it. So that's the hope, and then I'm going to give you 3 views about how to think about this process based on my early days of working on this. The 3 views are going to be the stakeholders, a theory about hammers, and why do not track is sort of a little bit like democracy. So I'll do those three in order. So the stakeholders. We heard earlier today on the panel, major stakeholders include the users, each of us, as we go surfing. We sort of want to have control and have it make sense to us. It includes advertisers who want to have their ads served. Their business is based on getting the right ads to the right people so they get paid more. So they give you the content that's going to lead to another stakeholder, the websites, right? If you have yourname.com and you're selling stuff, you might want to have advertisements that support you, and you want to have a structure as a website, a first party to do that. And then there's the browsers, and the browsers mediate between the users and all these websites and cookie people and advertisers. And so all we have to do to get an agreement is something that's better than the status quo for all of those players. Because the W3C is a consensus process. The idea is it's a standards process. We're going to have an interoperability win for the world from this. And so it's going to be better for advertisers, better for browsers, better for first parties, better for users, so that the groups who are in there, and there's 99 groups, if anybody signs up today, you can be the 100th member of the Tracking Protection Working Group, and W3C will welcome your contribution. Okay, so we got, we've got 99 groups here, and consensus doesn't mean everybody has to win, but it means pretty much, sort of, everybody's on board. And if that happens, we get a standard that scales, and then it actually happens out there the way we wanted it to. So that's a bunch of different groups with pretty different incentives, and we just have to get them all to have a win compared to the status quo. Okay, my theory of hammers. So you know that to a hammer, everything looks like a nail, right? If you have one tool, that's your thing. So I'm going to give you an idea. Let's imagine for a moment you're a tech engineer in Silicon Valley. What would you think would be the answer? I have an idea. Technical countermeasures, right? You're going to write some code because that's going to stop their bad code with your good code, and that's what engineers do. Okay, and we heard in the earlier panel today that we've got technical countermeasures waiting to happen if this deal doesn't happen. Another thing you might think if you're a Silicon Valley engineer is you might notice the 4 biggest browsers in the world are all headquartered on the West Coast of the United States. So maybe you'll get all the browser people together and come up with a standard, as has happened for lots of other browser things. And what do you know? Mozilla and other people went to the standards group, W3C, that does web standards, and they said, let's do a standard. We know how to do that. We've done that before. That makes sense. You can see why people do that. Now, we've had some people here from Washington, D.C. Now, Danny's sometimes at W3C in Boston and stuff, but Danny's from Washington, D.C. a bunch. I know where he lives. We go to the same temple and all that kind of stuff. I'm from Washington, D.C. too. Okay, I've just told you something. But D.C. people think that D.C. is really important. Like, we ought to have, like, a government solution to things. And I had Danny's quote from earlier today. That is something about the public policy folks will have to give direction to W3C. That makes sense because if the standards people by themselves can't do it, there has to be some government-based sort of thing. And that's the FTC tends to think they're going to be important. The White House has planned up here. Okay, so DC people, they think their hammers are the right hammers sometimes. And there's also these DC-based trade associations, especially the advertising companies. When you're a DC-based trade association, what do you do every day? You lobby the Hill. That's what you do. So the trade associations have gone up to the Hill and gotten members of Congress to write nasty notes to the W3C standards process saying, don't wreck the internet, be nice to the people that we're writing on behalf of. Because that's what DC trade associations and lobbyists do. And this is not a traditional W3C process. You don't usually have members of Congress lobbying in W3C, and all that, but that's the one we have now. And then beyond that, we have other people. We have the European Union has comprehensive privacy laws, of course. They think the right answer is to have, let's suspect, comprehensive privacy laws for this, and do not track should fit in with their cookies rules in Europe. So everybody's got their hammer, and they have their tools, and they want to do it. But is it going to be tech countermeasures or standards or DC-led or DC-blocked or EU? There's a lot of different possible players, and it's not entirely clear how that's going to work out. Okay, the third part is why do not track might be like democracy. And the answer, the idea I have here is the W3C might be the worst possible answer except for the alternatives, right? You've all heard this. I think Winston Churchill gets credit for this. Okay, democracy's that way except for the alternatives. And he was looking at Hitler and Stalin. I mean, he had something to work with. Anyway, that wasn't in my notes. So, okay, so a few weeks ago I posted on SSRN an article for the Wisconsin Law Review about imperfect alternatives for privacy, health IT, and cybersecurity. Basically, there's a professor at Wisconsin named Neil Commissar who's written about imperfect alternatives, why markets go wrong and government goes wrong, and how you somehow find your way through this. And his point is it's not enough to show the flaws in an organizational approach, because guess what? They all have flaws. Instead, the goal is to find among the various imperfect ways humans deal with this, one that's going to work or going to work better than the alternatives. So there are critiques of W3C. We heard some of them today. One is it's really a technology place, not a policy place. That has now been elevated to the status of a talking point by a number of players in the process. And also, this consensus thing is relatively hard to resolve conflicts. There's nobody in charge. There's no voting mechanism in the traditional sense of you have sort of the right number of representatives and everybody votes and you count them up. And so W3C might not be great at resolving values conflicts where it's really hard to know what your social values are. Let's look briefly at the alternatives. Alternative number one, Congress could pass a law. How are they doing at that these days? Right? I mean, they can't pass the laws they have to pass, much less as contested and complicated a one as this. So it's hard to pass a law in Congress. The FTC could do it. The FTC is going to be very involved, but they do not have regulatory authority. They don't. They've asked Congress, and Congress has said, no, not really. We want to be Congress. We want to stay in control. So the FTC doesn't have regulatory authority. We heard another variation, which is the raised eyebrow. But the effectiveness of the raised eyebrow is roughly based on how much they're going to smack you if you don't do what they say. And if they can't pass along, can't do a reg, that's a limited amount of power. There's some power, but just sort of saying, hey, guys, let's do it is not necessarily perfect. Plus, we notice those are only US-based solutions. The European Union exists. They have their solution. How is this going to work with over 500 million people in Europe? And so I guess the right answer probably would be a global UN-based organization like the ITU that would therefore bring everybody in with legitimacy of nation states and sort of govern the internet that way. So like there were like 6 chuckles, so you guys all haven't been living the Dubai conference in ITU. All right-thinking American internet people know that's the worst possible answer, right? That's just terrible. You'll give the UN people who want this are like Iran, China, Russia, and Saudi Arabia, right? In the name of internet freedom. And you're like, really? That's sort of an interesting list. Okay. So we don't have one world order. We don't have the EU. We don't have a really good way to do it at the nation-state level. We have the W3C. And how's that doing? Well, it might be better than the alternatives. It's got multiple stakeholders, lots of different industry experts from a lot of different perspectives. It is an interoperability issue, which is you have the do not track flag go out through the browser and people do standards things with it across the web. That looks like a web standard interoperable thing. That's what W3C's. The folks who brought you HTML could maybe bring you, an interoperable browser for this. And you have a lot of the right people in the room. I'm not saying for me, but you have a lot of the experts on all this that have, for whatever reason, gradually now 99 strong come into the process. And so there's a convening function. More or less, the people who know when something's stupid are willing to stand up and say, that won't work for this reason, and maybe we'll avoid all the really bad things that really, really won't work, and what's left might be something, maybe, we hope, that does work. And if it does work, maybe we'll have something that looks like a persistent, one-stop, widely recognized way for users to control their time on the internet. And wouldn't that be great? Thanks.
Ground rules for Q&A. I'm going to ask one question, and I'm going to have one person from the audience ask a question. That means we're going over our time, and we're running into your delicious free Palantir beer. And so the second ground rule is if the questions and the answers can be kind of short, we'll get to that free beer sooner. So here's my question. This is a question I was going to ask Danny. Danny, and you invoked the kind of law versus technology divide that makes this such a hard thing to hammer out. I read one provocative news report early on that said the secret is you need to find people who do both. You need to find these weird hybrid techie policy people, and the Berkeley I School and the Carnegie Mellon Public Policy School and Princeton are pushing these people out,
And Silicon Flat, this
Silicon
is the
Flat
room.
enzymes.
He's saying this room should take control.
So my question is, what do you think about that idea? Like, it's not the how, it's not the what, it's the who, right? It's because I'm frustrated in Do Not Track whenever I talk to a lawyer, and I know they don't know what they're talking about the technology. That's like my key concern. Is personnel the answer?
I mean, it's sort of a platonic, philosopher king, except today it would be the technologist lawyer, or policy person, or something like that.
They should run everything.
What?
Nothing. Go on.
I mean, that's more or less. I think one reason people ask me to do this is I've done technology for a long time, and I've done law, and I've done government. So there's at least a hope that maybe I can find people in those different places who can contribute. I don't know. We'll see. These questions do. Let me say it this way. You can't solve any of them with just law or just technology, but you can fail on any of them. If it's illegal or unconstitutional, that's not going to work. If the technology is broken and the flag doesn't send, that's going to. So you have to at least have enough capability on those dimensions so that you don't fail on any of those dimensions. That's necessary. It's not sufficient. We don't know what sufficient looks like, but that's at least necessary.
One question from the audience? People are already thinking about their beer. It's a great opportunity, people. Anyone?
I'll be at the reception.
All right, we'll be at the reception. Join me one more time and thank you, Peter. Okay, and rather than have you have a successive wave of applause, I got 2 minutes worth of things to say. I want to thank 3 groups. I want to thank the people who organized, Anna, Ariel, Cactus, and others. I want to thank all of the participants, and I want to thank you for being such a wonderful audience. So please join me in thanking them.